Are we all ready? Set?
We are ready when you are.
Okay. Señor Ronciclio?
También de nuestro lado, señor presidente.
We're also ready, Mr. President.
Welcome back to this hearing. This is the second day of our arbitration between Finley and others against the Republic of Mexico. As to housekeeping matters, as far as I know, the tribunal doesn't have any issue. I don't know whether you want to raise any point, either respondent or claimants. You don't, so we go straight to the examination of Mr. Finley. So, Mr. Finley, many thanks for appearing again here today, now as a witness. First of all, you may have in front of you a declaration that I would ask you to read to confirm that you are going to tell us the truth.
So I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
So many thanks. So now is the time for the direct examination by the claimants.
Yeah, so again, I'm Javen Porter on behalf of the claimants. Mr. Finley, would you introduce yourself?
Yes, I'm James David Finley, and I go by Jim.
What do you do for a living, Mr. Finley?
Yes, I'm an oil and gas producer, primarily, all in the United States. We have production in about 7 states, but most of our assets today are in Utah. And
Talk about some of the companies you own.
yeah, so being in the oil and gas business, we have some companies in Utah, some companies in Wyoming, companies in Texas. Those would be the primary places we have companies. But the ones here that we're talking about today are Finley Resources, that I started in 1997, and MWS, which I started in 2000. And we produce, 9,500 barrels a day, and we also have maybe 40 workover rigs today that work in the U.S. as well.
So how did you end up here today? How did you end up sitting in that chair?
Yeah, it's a great place to be, matter of fact, so not really. But in early, 2011 or so, and really in all my career, I like Mexico. I'm intrigued by it. So we started going to some meetings in Tampico and Mexico City, visited Costa Rica, and about during that time, Mr. Carrion had called me and asked if we wanted to partner up, and I said that we would. So we looked at doing this stuff jointly in some way. And so Pemex, we met with Pemex. Pemex did due diligence on us as well. They came to Fort Worth. They visited some of our horizontal locations. And generally, we discussed horizontal drilling, how it was progressing in the U.S. We just got done drilling some wells, and so they decided we're the kind of company that they wanted and desired to make investments in Mexico, and I thought it was a good thing as well.
What were they, at the time, what were they telling you?
Well, so one of the big deals would be, would they treat us fair, and would they pay us? And so those are the things I wanted to know, of course. And so as we went around, it was clear in my mind that they wanted to be a new Mexico, that they wanted to attract a significant amount of companies into the country, and to do that, people had to know they could be treated fair, and they had to know that they'd get paid. And one of the things actually that impressed me was we went to Mexico City and Tampico, and then the folks would say, Pemex pays, Pemex pays. The same gesture in Mexico and in Tampico and Mexico City. And then we went to Costa Rica, and they did the same thing. Pemex pays, Pemex pays. And so I was impressed by that, because it showed that they cared, that they had done enough to have some training or some kind of deal where everybody was on board with a new kind of Mexico. That's what I thought.
So they won you over, and what happened next?
Well, we went to Mexico. They came here, and then we decided to invest. And when we did, I guess, if that's what you're asking, what
Yes.
we did after that. So we decided to invest. The important thing was to invest in a long-term way. We didn't want to just go down and do one contract and come back. So it was a lot of decisions being made at the time, and we decided we'd import the equipment permanently on a long-term basis. That was about, if I recall, about twice the cost of doing it on a temporary basis. And we started buying equipment in the U.S. to fund that deal, which came from Finley Resources.
So how did you?
And MWS, both of those companies provided capital.
So how did you get the equipment to Mexico?
So we had a short amount of time, 30 days or 60 days. I can't remember the exact deal, whether it was 30 or 60, but it was basically having to fly the airplane while we were building it. So as we signed the contract, and perhaps even before the actual date that we signed, we started buying equipment, and we formed a company in Texas to do that. And then, well, my guys did, and later on I said, no, we need to do this in Wyoming because we've been doing business in Wyoming a while. They don't have any personal income tax, or do they have this harshest issues with sales tax, or they don't have a franchise tax like Texas does. So we formed a company called Drake Mesa, Wyoming, and that company was directed to go buy the equipment. Buddy Hines would be buying some, Alan Claiborne would buy some of our other folks would buy stuff. We accumulated it in that company, and it shipped it to McAllen and then across the border there when, let's see, who owns that now? Drake Mesa, Mexico owns that equipment at this point.
So when you got the equipment, did you start to perform in Mexico? Did your company start to perform under the contracts?
Yeah, we did, but there was a few other things we had to do. So the equipment came down there in waves, and all pumps on a truck, all hoses, all reverse units. So all of it came down to Mexico. Then we had to turn that into a drilling or a workover unit. In the case early on, they were all workover units. So we had to take a pump, a pit, reverse unit, and the rig itself, and all the ancillaries, and call that a rig. So we had to get it all ready to go to be inspected by PEMEX. So once it got down there, we got it all organized by unit. Then we had to do some retrofitting, some welding and things to make it PEMEX, fit PEMEX specs. We did that. And then PEMEX inspected it, and then we went to work after that.
When you say we, who are you referring to?
Well, the companies that were parties to the contract were, let's see, Finley Resources, MWS, and I'm not sure who the third one was. I can't remember.
I meant the employees is who you're talking about. Your employees?
Yeah,
Is it
well,
we?
I'm sorry, I didn't understand the question.
I'll rephrase it. When you say we, are you referring to your employees that were in Mexico?
Oh, yeah. So we sent down Alan Claiborne, and he spent a bunch of his time, I don't know, 70% of his time down there. We had a couple other folks that were there 100% of the time. And them together with Mexican welders and our personnel that was there, we got the rigs ready to go.
And you started drilling and
Yeah.
work over rigs?
We did. We worked over 400 wells for PEMEX during that period of time, and it was good for a period of time, and we were doing good. I think PEMEX liked what we were doing.
Well, so what happened?
Well, I mean, after that, they gave us a chance to accept a a contract called 804. And so I took that as a sign that we were doing good. And so we took 804 and brought more equipment down. Had to invest more money, but we got everything going with 804 as well.
And did you perform under the 804 contract?
Well, we did, but first time I heard yesterday that we also were involved in the tropical storm that Mexico mentioned yesterday. We were there. Our rig got flooded during the time that we were in the 804. And
Did Pemex issue work
yeah,
orders
so-
under the 804?
it was the time of 804. I'm sorry, what was your question? No.
Did Pemex issue work orders under the 804?
They did. They issued two, and as I recall, they issued two. We moved our equipment to location under a work order, and then Pemex canceled the work order and didn't allow us to start drilling. But the point here really is, and it was difficult for me to understand, was the tropical storm was just as an event, and we got rained on a lot. I mean, rain was as high as this table, but it didn't last very long, and it didn't prevent us from keeping drilling. We drilled 26 wells after that tropical storm. So I just like it wasn't that big a deal. We
So-
didn't get paid while we for the term of that contract. 809 did. We manned up and got our rigs going and drilled wells after that, and so it's a little disturbing.
So,
Mr. Porter, any other question, because your time, your 10 minutes is almost up.
can we just have a little brief, a couple more questions? Mr. Finley just wanted to address a couple
Yeah.
more things. So what happened at
Señor Presidente, nada más para tener un...
Mr. President, just to have some clarity, based on the agenda that we have for today, we understand that direct examinations would last 10 minutes. We will follow the time, but
Object to the claimant having the possibility to ask one or two questions? Otherwise, we'll stick to the timetable.
No,
we do not have an objection as long as it is reasonable, 1 or 2 minutes.
Thank you. So, we'll keep it brief, Mr. Finley, but, so what happened after the 804 into the 821 contract with your relationship in Mexico and your ongoing investment?
Well, yeah, so 804 starts, we stop and start, so I call Fräulein Gracia, and we talk about it. We're not getting paid, we're not getting work orders like we're supposed to be, and I said, we'll leave Mexico. This is not working out for us. And Fräulein, Mr. Gracia, said, no, we want you here. We want you to invest more. We know you've invested already, and we don't want to lose you. I'm gonna make this. I'm gonna personally talk to the CEO. We're gonna fix this. We're gonna get you paid. We're gonna get work orders going again. That's what he told me.
And you reinvested?
Yeah, and then then we went and signed 821, and I had to bring more equipment down for 821. I remember we had to do some retrofitting to make that rig work for what Pemex wanted in that area.
And I think we all know what happened with 821, so we won't go there. And I know you wanted to talk about some of the things you heard yesterday, and I'm going to give you the remaining time here just to discuss some of the things you heard yesterday and your reaction to it.
Mr. Porter, to the extent that later on the tribunal will have questions for Mr. Finley,
Okay.
probably
Sure.
we can wait for that and then give the floor to respondent for the cross-examination of Mr. Finley.
Thank you. Good morning, Mr. Finley. I'm Steve Becker.
Hey,
Thank you for-
Steve.
thank
Nice
you
to
for
see
be-
you.
Nice to see you. Thank you for being here today.
Yeah.
All right, Mr. Finley, let me just start out. You talked a little bit at the beginning of your examination about the many oil field projects you have in the United States, right? And so I just wanted to sort of get a little more detail about that. You said you had how many rigs?
I think today we have about 40.
40 rigs?
Yes.
And you're operating in Texas, in Utah, Wyoming?
Yeah, so the rigs are, they do the workovers on wells, and they work for us, and they work for other people as well.
Okay.
But we also own and operate, I think today, about 1,200 wells. We have we operate 1,200. We have an interest in 2,400 wells. So
Okay.
some wells we have an interest where we're not the operator.
All right. So you're a very busy person.
Yeah, I don't know that you would say that, but I work hard. Uh-huh,
I'm sure.
yeah.
So, Mr. Finley, before starting this first project in Mexico, how much research did you do about Pemex contracts? And more specifically, did you engage a consultant or a Mexican lawyer to sort of explain to you how the contracts worked?
I don't remember specifically, but likely we did, yeah.
So you weren't just relying on Mr. Kernian?
Correct, yeah. We would have had something other than Mr. Kernian.
Okay. Had Mr. Kernian had any prior contracts with Pemex through his other companies?
I believe so.
Okay. Let's go to your first statement, paragraphs, I guess it's 41, 42, and 43. We're going to be projecting it up
Sure.
here. And you're also welcome to look at your paper copy.
Paragraphs 41, 42, 43?
Yeah, this is, actually, it's 41 and 42.
Okay.
But it's basically, this is mostly 41. This is you're discussing, you met with your Mr. Froyland and then Mr. Lozoya at this conference in Houston,
Uh-huh.
and what have you. I just wanted to ask you, did you think Pemex was also encouraging other companies to enter,
Yes.
bid for contracts? Okay,
Yeah, they were.
okay. And contract 821 was awarded as a result of a competitive bid process, wasn't it?
Yes, it was.
Okay, so you had to compete with other companies?
Uh-huh.
Okay. All right. In paragraph 44, you discussed the fact that Pemex asked you for a financial guarantee or a performance bond, right?
Yeah, performance of work.
Okay.
Yeah.
So did that surprise you, or were you already aware that you were going to be required to have a bond?
Oh, I was aware.
Okay. Yeah, and you were aware it was going to have to be for 10% of the,
Yeah,
Full amount.
of the maximum amount.
I'm sorry. Yeah, we're talking over each
Yeah,
other, so we have to
that's
slow
right.
down.
We will.
So I would say you were aware then that you had to post a bond for 10% of the maximum value of the contract?
Yes, for the maximum amount of work to be performed.
Exactly. Okay. Are you fluent in Spanish?
No.
All right. So I was going to ask you if you read the Pemex contracts before they were signed, but
No,
Probably not.
I
Okay.
didn't.
so you deferred to Mr. Kernian.
Well, and
And
whoever
others.
was helping us, yeah.
Yeah.
We, yeah, I know we had somebody help. I can't come up with the name.
But you were aware they had the 804 contract and the 821 contract had maximum and minimum amounts?
I knew the 821 did. I think I heard that yesterday about the 804. I think I don't think I knew that specifically when I came in here on Monday.
Okay. And then, were you familiar, did someone explain to you all the provisions on terminations, how that would work, both by PEP and by the contractors?
I don't remember. I don't remember that.
Okay. All right. Regarding the various communications between PEP and the Mexican companies about the contracts, were you personally involved in those, or did you hear about it from others?
Can you repeat the question?
I'm saying, were you personally involved in the communications with PEP about the work orders and other things that were going on with the contracts? Or did other people report to you on that?
Yeah, I wasn't involved in that.
Okay.
Is that mostly a question about the day-to-day operations?
Yeah, did.
Yeah, no, I wasn't involved.
Okay. All right, let's go to paragraph 59. And in these next few paragraphs, this is where you're discussing the plunge in oil prices. And
Yes.
You're welcome to take a minute if you want to read these paragraphs, but I think you're familiar with it,
Uh-huh.
right? So basically, you're reviewing here how the prices started to drop, and then you have this very helpful chart or bullets in paragraph 61, if you scroll down.
Yeah, I see.
Showing
61.
is the prices when you sign the contracts,
Uh-huh.
and then next page, please.
Yeah, you want to look at the graph?
Yeah, or we could look at
Yeah.
that, but
Went
we
to-
could just see here, they're saying, so the price decreased from $103 to $46, and then it dropped to $26,
Yeah,
right?
I remember it,
Yeah,
unfortunately.
we all do.
Yeah, we do.
I'm sorry again, yes, my fault.
Yeah,
So the price dropped by 75%.
yeah, it sure did.
Okay. Now, in paragraph 64,
Uh-huh.
at the end, go down, right? So say, the very last sentence, right, start at the top of page 16. This is where you say, by default, we were taking the risk of the price of oil, which was never the intent for us under the contract,
Sure,
correct? Okay.
yes.
And we heard this during the opening. I just want to confirm to you that you felt that the price of oil was totally irrelevant to the business and that your projects were risk-free.
They were not risk-free by any means, but as to the price of oil, we were not taking a price risk, given the minimum and maximum in the contract.
All right. And then let me ask you, in you're very experienced, have you ever before had a customer or supplier that had financial difficulties before this?
Sure.
Okay. All right. Let's move on to the second statement. Yeah, let's go to paragraph 6. And this is when we first saw that you created this company called Drake Mesa LLC.
Okay, well, I'm sorry, that's, what page is that?
It's their second statement, paragraph 6.
Oh, second statement.
And you talked about this a bit in your direct examination about creating a company in Wyoming.
Yeah.
All right. Let's go to R137. It's going to be projected. So scroll down a little bit. So May 4th, 2012. Keep going. So we see here it's organized under the law of Wyoming, right? You've already said that. Okay. And then let's go to the last page. Exhibit A. And here we have an exhibit that shows us who the owners of the Drake Mesa LLC were. So we see that you individually owned 44.9%.
Uh-huh.
And then Mr. Hicks and Mr. Hines, I think, were your employees. Is that right?
They were owners in NWS.
Yeah.
Yeah, this is kind of an NWS ownership.
Right, but they own these individually, 2.5% and 2.5%. And then the other 50% we can see was owned by Bissell, I'm sorry, it's Bissell, right? Is that how we pronounce it?
I've heard it both ways.
Okay, thank you. All right, I'll go with Bissell Exploration US, which I assume was Bissell Exploration LLC. Isn't that right?
I wouldn't know exactly.
No, but it says the only owners are Mr. Wendorf and Mr. Kernian, and they own 50%, right?
I don't know how much.
Well, it says right
That's
there.
what that document says, yeah.
Yeah.
Uh-huh.
Okay.
Sure.
So this shows that you were owned about half of the company in your personal capacity, correct?
Uh-huh.
And this,
That's what it shows.
sorry,
Could you please answer with a yes or no when you're giving a number?
Uh-huh. Thank you.
All right. So if we look at this, Finley Resources, Inc. did not own Drake Mesa LLC, did it?
No, they're not on there.
No, and nor did MWS Management.
Well, that does mirror the ownership of NWS
But
Management.
MWS Management, excuse me for talking over you.
Yeah.
But MWS Management isn't listed as an owner.
They're not. That's
It's
right.
you in your personal capacity.
Well, that is that's the owners.
Okay, all right. Now, Drake Mesa LLC, this entity, was the one that you say purchased the equipment, right?
Yes, uh-huh.
Okay.
Yeah, it was formed for the sole purpose of buying and accumulating equipment, some of which came from MWS directly, some of it which we bought. So we moved all the funds from FRI, from Finley, into this Drake Mesa company, and then bought the equipment on behalf of FRI, and then we moved it to McAllen.
All right. Let's go to paragraph 9 of your second statement. And again, we're going to project it here. Yeah, by the way, there's a screen right in front of you, if that's helpful. So I'm focusing on the second sentence where you say, I caused a report to be created that lists the assets that were purchased in the U.S. and used in Mexico for all of the contracts that's attached. And if we look down at the footnote, that's the C-148, right?
Uh-huh.
Okay, so let's go to C-148. So this was asked yesterday, but not to you. Uh, Can you explain to us how this list was generated?
So I would be speculating.
Okay,
I mean, it says it's QuickBook report, so this came from our QuickBook systems.
okay, but in your witness statement, you said you caused this report to be created.
Yeah, I would ask somebody to create the report.
So how would they do that?
So they'd go into the computer and print it out.
Okay, but how was this information entered into the system?
Yeah, so as we bought the equipment, we entered into the accounting system the equipment we bought, and I assume we reduced cash by the same amount as we made each entry, and then we'd have the backup for it, I guess.
Okay. Let's go to R-150. So this is the cover page for an Excel file that we were provided in document production, and it was given the same sort of identification number as the Excel file.
Yeah.
So you see the file name is Drake Mesa Fixed Asset List.
Uh-huh.
And let's now go to the associated Excel file, and that's R-150. I'm sorry, 140, what is it? 141, I'm sorry. And it appears to us, if you could scroll down a little bit, that this seems to match the QuickBooks printout.
It does, yes.
Okay. So what's the source or purpose of this Excel file?
The Excel file?
Yeah. Is this how the information was loaded into QuickBooks?
I wouldn't think so. Which Excel file are you talking about?
This one.
Oh, this is a QuickBook file.
This is, well, it's an Excel file in native format.
Okay, I wouldn't know that. I just know it said QuickBooks at the top, and I would assume it came out of QuickBooks. If it got imported into Excel or something, I wouldn't know that.
Okay. I'm just curious as to, if we already had this in QuickBooks, why was it also prepared in this Excel file, do you think?
Well, I don't quite follow your question. I think this was in QuickBooks, and we printed it out using whatever QuickBook format is for printing stuff like this out.
I see. Okay. So I guess if we go back, you're saying at the time, someone was looking at the invoices and saying this will go to Drake Mesa LLC.
Uh-huh.
Okay. Let's go back to C-148 because it's easier to work with. Okay, so if we scroll down here, we see, we can make it a little bigger. I just want to focus on that column that shows that virtually all the purchases are from 2012. Can you see that?
Yeah, all of this is in 12, yeah.
Okay. Now, let's go to page 14 of this document. And if we look up, there's a transaction on March, let's see. Yes, March 23rd, 2015. It's about the 7th line down. And if we go over to the more to the middle column, we'll say it's a charge for moving rigs from the border to Jordantown Yard. Can you see that?
I do. Uh-huh.
Okay. So in 2015, some rigs are being moved from the border to your location in Jordantown, Texas. Is that right?
I wouldn't know. I don't know that level of detail.
Okay.
Yeah.
Could you speculate on what else that could mean?
Objection.
I
Well,
think all
they're
the
asking
rigs
him, objection. They're asking him to speculate. He just said he didn't know the answer.
Well, I'm sorry, this is a document that he provided, right? It's you provided it.
Let's talk to the tribunal.
Yeah.
Thank you.
But I think that the question is a legitimate one. So if you don't know, you just say, I don't know, but the
Right.
question is fine.
Right.
And by the way, probably if you say yes rather than aha, that would be helpful
Oh,
for
right,
the
exactly.
stenographers.
Yeah. I don't know, and I just assumed all our rigs are still there.
Okay. But
Yeah, I don't remember
it doesn't, yeah,
anything like
this
that.
doesn't suggest to you that some rigs were moved back.
Yeah, I don't know.
Okay. All right. And you're saying now the other rigs are all still in Mexico?
I think so.
Really, what are they being used for?
Nothing.
So you
I think they're rusting.
why wouldn't you bring them back?
Because I think the cost to bring them back is more than the cost of their value at this point.
Did you
And
write
there's
them?
been a lot of pilfering, and they're just not. It's easier to buy something in the U.S. than to bring those back.
So you abandoned them, is basically what you're saying?
I don't know if that's what that means. I hope we still own them for some value, maybe. I don't know that we've abandoned them.
Did you take a tax write-off for them?
I don't know.
Okay. Let's go to C-158. 158, okay. All right. Oh, no, sorry, that's the wrong document. Never mind. Only for the, is that it? Oh, sorry, you're right, okay. So I want to go to page 4, forgive me. Okay, this is part of this long exhibit C-158 with all the documents, and it's an equipment lease agreement. So we see it's the first page. It's an equipment lease agreement between Drake Mesa LLC and Drake Mesa SLSDRL, which we'll call Drake Mesa Mexico.
Sure.
Okay?
Uh-huh.
Okay. And then we'll go to page 7. And it says, lease only. This agreement constitutes a lease of the equipment. It is not a sale or the creation of a security interest. You see that?
I do. Uh-huh.
Okay.
Yeah.
So these rigs were leased but not sold, correct?
What is the date of this agreement? If it's what I think it is.
Go down to the end. I think page 10, April
Yeah.
2012.
Yeah, April 2012. That's right after we signed 803. I don't think we ever did this deal. This was an idea at the time, but I don't think we ever consummated it.
Okay, but you provided it to us as your proof of the purchases.
Yeah, it was a document I guess we had.
Okay. Continue with this exhibit. I think we started with this yesterday, but we're going to look at a few more of the purchase receipts for the equipment. So let's go to page 24. So again, here's an invoice made out to Drake Finley LLC from Atascosa Fire Protection. You see that?
I do.
Let's go to page 25.
I'm sorry, what'd you say?
I'm just instructing my colleague to go to page 25.
Oh, okay.
All right. Mesa Safety Services, another invoice made out to Drake Finley LLC. You see that?
I do.
Okay, let's go to 27. Another invoice made out on the upper right to Drake Finley LLC, right?
It does.
Okay, let's go to page 32. And the upper left, again, Drake Finley LLC, right?
Yeah, uh-huh.
Okay. There's lots more of these. We reviewed some of them yesterday. I don't want to take up everybody's time. Will you concede that most of the purchases were made by Drake Finley LLC?
For the ones you showed me, it depends on the dates of them too, because as I said, we started out with this Drake Finley company for the first couple of weeks or couple months, whatever it was, and then we decided to dissolve that company and do all the business out of Drake Mesa, a Wyoming company. So these early things were during the time we were building the airplane while we were flying it, and so those transactions ultimately were assigned to Drake Mesa in some way.
Actually, we went through all those invoices.
Well, we went through
And other
4 or
than
5.
Other than that lease, no, in all the 600 pages, and
Uh-huh.
other than that lease, we actually didn't see anything.
Objection.
Yeah.
That's not correct. That's an incorrect factual statement. There's invoices in that were associated with Drake Mesa LLC as well. It's an incorrect factual statement.
Well, let's keep going then. Let's go to page, let's see, where were we on, 32? Let's go to 52.
That one went from Drake Mesa to Mesa Southern.
Yes, we're going to get to
Yeah,
that in a second. Okay. Let's go to page 63. All right, again, Drake Finley LLC, 65, Finley LLC,
Uh-huh. And we should look at
97.
we should look at the dates when you're looking at this as well. 'Cause I think the dates will coincide with which company it is.
Sure. Okay, let's go to 161.
That's February 15th, 2012.
Mhm.
Yeah, that makes sense.
Okay, let's go now, let's shift over to the other purchasers. Let's go to page 26. So now we've got sales made to Mesa Southern Well Services LP, right?
Uh-huh. It's MWS.
Yeah, and that's a, no, that's a limited partner, Texas Limited Partnership, isn't it?
Oh, that's Mesa Southern. I'm sorry.
Yeah. Okay,
Uh-huh.
that's a separate limited
Yeah.
partnership.
Uh-huh.
And it's created in your name, correct? You created it.
I think that one, I think Mesa Southern is me and Alan Claiborne and Mike Hines maybe that own it. Is that what you're asking?
I'm asking, I'm going to ask you to be very careful and just tell me, do you absolutely know?
Yeah.
Because I'm sorry, we didn't have time. We can pull the organizing documents and ask for your leave to submit them later.
Right. Okay. I'll try to refrain from speculating and
Okay.
only answer what I know.
All right. Okay, so let's go to page 51. Again, Mesa Southern Well Services, page 70.
Yeah, we were going to look at the dates as well.
Sure. It's February
Uh-huh.
79. Southern Well Services, 82,
February again.
105, or sorry, 165.
Yeah. That one went to Mesa
I'm so
Southern.
sorry. Okay.
Uh-huh.
You want us to go back? Okay. Let's go back to 70. Slow down a bit. My apologies.
That's February 29th.
Mhm. Right. Okay, page 79.
That's February 17th.
Page 82.
That one is February 16th.
Page 165.
That one is February 10th. And you can see kind of we were flying the airplane. I guess Mesa Well got crossed out, and Drake Mesa got
Okay.
kind of during this period.
Okay. Now, I think we've discussed that, okay, let's go back to Drake Finley LLC. So that's a Texas entity though, right?
Which one?
Drake Finley LLC.
I think so.
Okay. And you were the sole owner of Drake Finley LLC?
I don't know.
Okay. Let's
I don't know.
let's go to exhibit R-154.
Okay.
All right, so this is publicly available information from the Texas state government.
Uh-huh.
And we put this up here. You can see the documents they have available. And we can see a certificate of formation, a certificate of correction, and then a certificate of termination, right? Well, from February.
Yeah, okay. Formation February 2nd, correction February 7th, and then in 13 we shut it down. Yeah.
Okay, so let's go to R-153. So what what I wanted, 151, excuse me. Okay, so then we see is that when you originally filed this, you accidentally put Drake Mesa LLC in, which is, and we'll get to the correction in a second. So here you file or even though you put it in the system as Drake Finley LLC, you put in a certificate of formation with Drake Mesa.
Objection.
Yeah.
Argumentative. I think he can ask the question. I mean, he can ask him why he did it. Mr. Becker's providing his opinion on
Well,
why it
but he's
happened.
providing background before the question is raised.
I'm going to take
so-
you to the next document that shows the correction. I'm taking this through chronologically so it's clear for everyone. All right. So let's skip to the end. Whoops, not to, yeah. So it shows here that you are the member, correct? Yeah. Okay.
That's what it shows.
Okay, very good.
Sorry, I don't know if the microphone is on when you're on.
Oh,
Thank you.
Thank you.
okay.
What's your answer? Yes, you think?
Excuse me, so she asked you to repeat your response.
Oh, the answer was yes.
Thank you. All right.
Excuse me, Ms. Berker, just to understand your previous question and remark.
Yeah.
You said that in this document there was a mistake.
We're going to get to that in the next
okay.
document.
Yeah.
I just have to take it
Yeah.
through chronologically, otherwise it's very
Yeah.
confusing.
When we first formed the company, I was the manager, I guess.
Okay, very good. All right, so the next document is R-152. So then, a few days later, someone apparently has noticed the mistake, so that you file a certificate of correction, and he said that the correction is that the certificate of formation of Drake Mesa LLC contained errors. Scroll down. The name of the entity was erroneously stated, and it's deleted its entirety and replaced with Drake Finley LLC. You see
Yeah.
that?
I see it.
That makes sense.
Uh-huh. Yeah, it somewhat does, yeah.
Okay,
I don't remember all this, but it does somewhat.
sure.
What exhibit number was that again?
That was, that's 152. And now let's go to 153. And then, I guess a year or so later, in March of 2013, you terminate the LLC.
Yeah, uh-huh.
Okay. All right. So it's fair to say that neither Finley Resources nor WMS Management own Drake Finley LLC.
Yeah, based on that, that's true.
Okay.
But it sure funded them.
All right, but it didn't own them.
Didn't own them.
Okay. And that's also the case with Mesa Well Service. Well, never mind, we discussed that before. I withdraw that question. Okay. Now, Mr. Finley, one of the things I'm confused about is that why were purchases made by Drake Finley LLC listed as assets of Drake Mesa LLC?
I don't know what you're talking about exactly.
Well, we have all these purchase orders, right,
Uh-huh.
that are then just sort of put into this fixed asset list of Drake Mesa LLC, even though the purchases were made by Drake Finley LLC and by Mesa Southern Well Services. So I'm just asking, why aren't those assets of those companies? Why are they listed as assets of another company?
Well, I'm not sure that they are. I mean, I'm speculating, but
Okay.
there's certainly, we shut down Drake Finley, a Texas company, and moved all those transactions to Drake Mesa, a Wyoming company.
You move the
Because-
transactions.
Well, the funding, so we shut one company down, and there's accounting entries you can make where one company assigns its assets and liabilities to another company. And I'm speculating how we did that or what we did, but
Okay, but we don't.
but whatever we
don't-
did,
We don't know at this point. Okay.
Objection, he answered exactly how it happened, and if you want to say it again, Mr. Finley, I think you can.
Forgive me, maybe I misheard him. Did you say that you have it absolutely certain that's what happened, or did you say that's what sometimes happens?
no, I'm saying that I remember shutting down the Texas company
Yeah.
and forming the Wyoming company.
Uh-huh.
And our normal business practices are to follow generally accepting accounting principles. So I don't know how we did the mechanics of that,
Okay.
but our company policy is to follow generally accepted accounting principles.
Okay. But before, you said that sort of in the course of business, as the transactions were being completed, they were being entered into QuickBooks for
Uh-huh.
Drake Mesa.
Yeah.
But this makes it sound like there was some shifting that went on a year or so later.
What went on a year or so later?
Well, again, the QuickBooks account, you said that we're keeping track of the transactions as they happen and we're loading them in.
Yeah.
So is it the
As a
case?
general statement,
Yeah.
I'm not sure if every single transaction occurred the same way.
Okay,
I wouldn't have that level of detail for sure.
understood. But from what you just described, it's possible that a year or so later, someone said these transactions that were made by these other companies were going to move into Drake
I don't know if
Mesa.
it was a year or so later at all.
Well, we just discussed that Drake Finley was terminated in March 2013, right?
Right. But that didn't mean, generally what we do is we look through our list of companies and ones that are done or the project's over or whatever,
Yeah.
we'll go ahead and terminate those so we don't have to do a tax return. So a
Okay.
tax return itself is a couple $1,000s, and so if we got a dead company, its business is over, we try to proactively terminate those.
Okay.
And we
But-
do a couple a year probably.
But Southern Mesa Well Services LP, though, is still in existence, isn't it?
Which one?
Southern Mesa, forgive me if I'm getting the names confused, but Mesa Well Services, sorry.
Mesa Well Servicing.
The one we went through all the invoices for.
There's Mesa Southern Well Servicing
Yeah.
that I know of.
I'm sorry, forgive me, I think you're right. That's the
Yeah,
name.
yeah.
Of course you would
Okay.
be right, yeah.
Mhm.
But that organization has not been dissolved, has it?
No, it's active today.
Okay, but you still shifted its purchases to Drake Mesa LLC, correct?
Yeah, it would have. I mean, if it had something or some of it came out of their inventory, there would have been a proper accounting for it, I'm sure.
Okay. Let's go to paragraph 6 of your second statement.
Is this my statement?
Yeah, the second statement.
Okay.
Again, it's projected in front of you. So you say here at the end of the second sentence, you say, "I understand that ownership of the rigs transferred to the Mexican entity."
I didn't quite hear it. I was reading, sorry.
Sorry, no problem. I'm just pointing out, I wanted to highlight the end of the second sentence where you say, "I understand that ownership of the rigs transferred to the Mexican entity."
Yeah, uh-huh.
Okay. So you didn't, that was your understanding, but you didn't point to anything that showed us that that was actually the case.
Right, uh-huh. That is my understanding.
Okay,
I know there's some, that was a long time ago, and I'm not an expert at all.
Okay.
But as I understood it, when the equipment crossed the border, it became the property of Mesa SDRL, Drake Mesa SDRL. That's how I recall it.
all right. Do you have access, well, let's call that Drake Mesa SRL for convenience. We'll call it Drake Mesa, Mexico.
Thank you, okay.
Yeah. Did you have access to that company's financial records?
Sure.
Okay, because I asked because no such records were submitted into the record of the case.
Okay.
So how can we tell that Drake Mesa, Mexico owned the rigs?
I don't know.
Okay,
Other than the importation documents,
yeah,
I think we gave those, and I don't know about the financials. I don't really know.
okay, fair enough. Now, Drake Mesa, Mexico was not a party to contracts 803 or 804, was it?
I don't.
That was Bissell, right, wasn't it?
I don't know.
You don't know, okay.
Yeah.
Because earlier in your direct testimony, you said that it was a party to the 803 contract, but,
I think FRI was on all of them.
I'm not going.
Go ahead.
Yeah, yeah.
What are you asking?
Okay. So
If-
you're not sure which companies were parties to the contracts?
Yeah. So you asked me if Mesa Mexico was party to 803.
Yes.
I think so.
Okay, and you also think that Finley Resources, Inc. was a party to contracts 803 and 804?
I think so.
Okay,
I'm not 100% sure.
all right. Are you aware that Bissell, Mexico was a party to contracts 803 and 804?
No. But I knew some of Mr. Oseguera's entities were, sure.
Okay. Now, excuse me, I need one moment. All right. So you are aware, at least, that Mr. Kernian's companies were involved in the projects, right?
Yes. Whatever, I don't know what you mean by process, but
The projects, involved in the projects.
um,
Contracts 803 and 804?
yes, yes.
Okay. And again, are you or are you not familiar with the company Bissell Construcciones?
Yeah, I'm familiar with it.
There's an explanation. Okay.
Sure.
Okay,
That's one of the companies I know Luis has and worked in Mexico.
right. That was one of the companies with which you were working, your companies were working.
Well, they had their own stuff and we had our own stuff. I don't think there was any joint stuff between the two companies that I know of. They had their own contracts. And are you asking about the equipment,
Yeah,
right?
yeah.
There wasn't a lot of, I don't know of any cross-pollination of their equipment and our equipment.
Okay,
And our equipment is what we were doing in Mexico under 803, is what I'm referring to in my mind.
mhm. Yeah, we need a minute to put up the contract.
Sure.
Yeah, 803. All right, we put up the cover page. What is it? This is
C-32.
C-32. Okay, so we're putting up contract 803. So you see the contract was with Bissell Construcciones and MWS Management. Do you see that?
I don't read Spanish.
Well, I'm just asking you about the names. the
Yeah,
name
I
of
see the names
provider.
in Spanish.
Yes. We can pull up the English translation, but I'm really just asking you about the parties on the contract.
Yeah, it's Bissell Construcciones and Intergeria S.A. de CVE, okay, MWS, I see.
Okay, so that's not Drake Mesa, Mexico, is it?
No, it's MWS Management and it's Bissell.
Okay,
Yeah.
all right. So, again, Drake Mesa, are you saying that Drake Mesa, Mexico performed this contract?
No, I'm not saying, because I don't know.
Okay,
I'm not saying that.
all right,
But I see MWS here, yeah.
okay. Let's go to paragraph 9 of your second statement. We've looked at this before, but then at the last sentence here, you say, "We purchased other assets in Mexico that are not yet listed in this report."
Yeah.
Why are there no records of those purchases?
I don't know.
Okay. All right. All right. Well, thank you, Mr. Finley. I mean, that's all the questions I have for now. Thank you, Mr. President.
Many thanks, Mr. Becker.
You bet.
Probably my colleagues may have, by the way, Annalise, it's time for break.
The break was scheduled at 11, but if you'd like to take a break
Okay.
now.
Shall we continue for a while? Well, before my colleagues may pose your questions, we know that the ownership structure of the Finley Group and also of Luis Kernion's companies is a complex one. But I'm myself a bit lost in this maze of companies which are terminated because it's cheap. And could you give us a broad overview of what was the corporate structure of what we could call the Finley Group and the relation to the project? Because I know that you are the main owner of Finley Resources and MWS, but then there is an array of companies which appear on an off basis. And if you could give us a big picture of the structure, corporate structure of your group, and ideally of Mr. Kernion's group. Otherwise, I will ask that question to him.
Could you turn your microphone on, please, Mr. Finley?
Thank you very much. I guess to start out, the two companies that have assets that are the main source of my assets are MWS and Finley Resources. So I wouldn't have had the money personally to invest in Mexico other than through Finley Resources and MWS. So Finley Resources owns and operates properties in 7 states, has 9,500 barrels a day of production. And so it does that. And then MWS is the manager of Mesa Well Servicing, our company that has workover rigs. And they work for Finley Resources, some, and then they'll work for even Exxon and companies like that, some as well. And so with the production company, Finley Resources, that drills wells, produces oil on a daily basis, sells the oil, and drills wells, so we had that expertise. And then on the NWS side, we had the expertise to do workovers and have done thousands of workovers in the United States. And so those two companies together is where the money came from. The only place I had money of this kind to make this investment. So when we signed the contracts, we had a short amount of time to get this done. And so we quickly formed a company in Texas. And you could see I was, at the time we formed it, I was the only owner myself to get the paperwork done. Then we started buying equipment. And then I got to thinking about things we'd done in the past. We didn't want to pay sales tax in the U.S. when we were going to ship it to Mexico. And I didn't want to have to worry with Texas franchise taxes, and Texas has other taxes that Wyoming doesn't have. Wyoming is a very small state in terms of population, so it has very lax laws on sales tax and things like that. So we were able to move the stuff that we did early on for, I don't even think it was 2 months worth. All of the transactions we assigned over to the Wyoming company. And I don't know exactly how we did that, but our policy would be to do that the right way. So we directed the buying of the assets in Mesa, first in Drake Finley for a few months, maybe not even that long. And then we went to Drake Mesa, Wyoming, and bought the equipment there. And because Drake Finley wasn't doing anything, we shut that down the next year. And then Drake Mesa, Wyoming continued to buy the equipment. And we bought it from all different kinds of places. Some of it we couldn't find because oil was $100 a barrel, so we were paying a lot high prices for equipment. So some of it we took from our own inventory of MWS and contributed that as well. And we made the right entries across the board, I'm sure, for that. And so that company, Drake Mesa, Wyoming, had all this stuff, and then we moved it to the border, and I believe it at McAllen. And then at the border, we paid the tariff to move it into Mexico on a permanent basis. And then, as I understand it, at that point, the equipment became owned by Drake Mesa, SDRL, or whoever was the importer of the equipment. I don't think at the time we had formed Drake Mesa in early 2012, so I'm not, whoever was the importer of the equipment would own it.
And you said that Drake Finley, Texas, was terminated in 12/13.
Yeah, we.
But,
I'm sorry, I didn't mean to interrupt you.
But we know that in Mexico there were two, one Drake Mesa, Mexico, and then Drake Mesa Finley, and Drake Mesa Finley actually was one of the parties to the contract 8-1. And why did Drake Finley remain in Mexico while Drake Finley in Texas was terminated?
Yes, so Drake Finley in Texas was only conducting that business during the short amount of time in early 2012. And then we transferred everything to Drake Mesa, Wyoming. So Drake Finley, a Texas company, was not going to do any more business, so we terminated it so that we didn't have to continue to pay our accounting firm to file a tax return every year. And I probably shut down a couple companies a year that do stuff, and then their tasks are done, so we just shut them down and then just keep them going for a long time. And I think we did the same thing with Drake Mesa as well. Once we had the equipment bought, we'd not needed that company to do that specific job anymore. We shut Drake Mesa, Wyoming down as well, if I recall.
Yeah, but just out of curiosity, the name, not the company, but the name Drake Finley. So you terminate the Texas company in 12/13, but the name as a Mexican company reappeared when you enter contract 8-1. So
803?
No, 8-1, because
821.
that was a special purpose vehicle to operate the 8-1 contract.
Yes.
That was signed in 2014.
Correct, yes.
So once the Drake Finley, Texas had been terminated,
yes,
the Drake Finley name, not the company, appeared as Drake Finley, Mexico.
It's a little unfortunate, yeah.
Is there any particular reason for for
Yeah.
that name?
Not really. No, it's unfortunate. I guess they were just convenient names, maybe. I should have been better at that.
And
Naming
the-
them different, yeah.
And concerning the name, just the name, Drake Mesa, what's the origin of that expression, Drake Mesa?
Yeah, so Drake, I always associated with Mr. Curion, and so I wanted to do something to put his name in front of my name, and so that was Drake is what I associated him with, and then Finley is us. So that's where it came from.
Well, and this brings me to my next question. Could you give us a sort of an overview of a history of your relations with Mr. Kernion? How they developed? When did you meet him?
Yeah.
And what was the split of functions in this project between you and Luis Kernion?
Yeah, sure. So I met Mr. Curion in probably late 2011 when we started our due diligence process, going down to Mexico to presentations that Pemex was making. We were getting to know each other at that point in time. And so I met his family, he met my family. We got to know each other to a point that I thought we'd be good partners. And so we decided to do this together. It's basically one where I brought capital, we brought the expertise in drilling wells, we brought the expertise in workovers, and he had the expertise in Mexico itself, which I did not have. And so it seemed to be a good equally distributed way of looking at it. I put in more capital, I don't remember how much, but more capital than Mr. Curion did. But Mr. Curion did more work day-to-day than I did. It wouldn't be day-to-day that he did, but I certainly wasn't, I wasn't in Mexico as much as he was, for sure.
Yes, and as you said, you're obviously an oil businessman. You're not an accountant or a lawyer.
Correct, yes, right.
And then my question is, who was managing the project in Mexico for the group? It was Mr. Kernion, because probably you said you were not involved, not only in on a day-to-day basis, but probably you just were concerned with business, the
Yes.
earning statements and the like, but not on the detail on how they were managed.
Yes, but MWS, we had employees from MWS, which would have been Alan Claiborne, who spent about 70% of his time maybe in Mexico. And I know we had two other employees that spent 100% of their time in Mexico. Eddie Escobar, I think, was his name, and then another person. And they managed part of the operations. They were the ones that got the rigs ready to go. And then they were down there as part of the day-to-day management as well.
Yes. And from your previous questions, it's obvious that you were not involved in once the different companies started lodging suits against Mexico in Mexico. You were not involved in those suits. You didn't know much about the technicalities of those suits. And I understand that you were using as advisor in Mexico Mr. Paullada. Do you know him? Or?
No, I never met him. That was something that Mr. Curion was involved in. That must have been in 2000 and, I don't know, later on, right? 2018 maybe, something like that.
And then who was controlling that the legal strategy followed by your group in Mexico, in Mexican courts, was the right one? And that you obviously you were not. It was Mr. Kernion who was controlling the lawyers working on your behalf in Mexican courts.
Yeah, I don't know. I know one of them was named Christina, but I don't know her last name. But I did have a dinner with Christina, I believe, in Mexico City. And then I think at some point we had, I don't know if it was Thompson Knight, but another U.S. company that helped us. We had a company out of New York, a law firm out of New York that developed our Foreign Corrupt Practices Act policies. So we had policies, we had training, we distributed the policies as well. And then I guess I did go to Mexico some. I wanted to understand if we had competent labor, safe labor. And so I went down and met some of our crews just to get a feel, them get a feel for me and me get a feel for them. And it turns out some of the crews in Puerto Rico were also crews that worked for MWS in the U.S. at one point in time. So
Okay.
I had some, no technical, but I wanted to understand what we were doing and how our people were being motivated.
Okay, thank you, Mr. Finley. Hello, Franz? No further question? Any?
No, I am.
Sorry.
Good morning, Stephen.
Good morning.
Well, first, I have three questions. My first one is related to your written testimony. At paragraph 24, you write, Pemex did not have the resources to develop Chicontepec. My question is it predictable or is it usual that resorting to foreign companies necessitates less resources than doing it directly?
So I think your question would be, is the Chicontepec area as rich as some of the areas in the U.S. in terms of the amount of resource available?
No. It is more financial than that.
Okay.
You say Pemex had no resources to do that, so why hiring you cure the situation, if I may say that?
Sure. I think in its which paragraph are you referring to?
24, I think.
20?
24.
24. Yeah, I think I understand what you're saying.
Pemex did not have the resources to develop Chicontepec.
Yeah.
So my question, they don't have the resource
to
develop why would they have more resources to pay you?
Yeah, that's an interesting question. So in the U.S., all of our production information is public. What every well in the U.S. produces every month is public information. And more importantly, every well has a method or infrastructure to allocate the amount of production that well is. Because we have private ownership, and every owner under a well is entitled to their exact share of production out of that well. But in Mexico, all of the production is owned by the government. And so they didn't spend as much care and time to understand every well. They might have 10 or 15 wells all hooked up to a central place, and you didn't know which wells were doing what. So they didn't have the resources because they didn't have because it's all public minerals, they didn't have the care that the U.S. would have so that you could know for sure what's going on and therefore evaluate where you ought to drill wells, how you ought to develop a field. So there's a kind of a vacuum, in my opinion, of information that we utilize in the U.S. and what Pemex really had as a starting point to try to get this Chicontepec field developed.
Thank you. This is a good introduction to my second question.
Okay.
You say, answering, I think, Mr. Becker, that Pemex did due diligence, or is it? Yeah, and we did as well. But what kind of due diligence did you do besides chatting with a representative of Pemex?
Yeah, so we visited some small business owners in Costa Rica, and kind of got to understand the maybe during 2 or 3 dinners and visits with some small businesses, what they were doing. If they could get funding for their business, and that seemed to be a problem for me, is the ability to go borrow money at a bank and operate like we do small businesses in the U.S. I wanted to understand and whether or not they thought the rule of law was changing. That was a big deal.
No.
Yeah, and then I did go visit the newspaper office in it's either Monterrey or Mexico City. I can't remember now. But there was a mock-up of a American-style courtroom in the building of the newspaper, which it made an impression on me that there's some real concern that the rule of law be upheld, is what I thought. So certainly those were parts of my visit. We did tour the field, I think, with a Pemex representative and look at some wells in the field as well. So I did what I thought was a reasonable amount of due diligence.
But you did not committed general study on the oil market in Mexico?
Yeah, we weren't responsible. We didn't own the well, so we weren't responsible for marketing. But it was a curiosity to me, and one of the things that was curious was going back to the way production. So all of the oil and the gas went down the pipeline, and the oil went into centralized tanks that had a huge amount of wells, and the oil and water would go to these wells, and then the oil would be separated from the water, and the oil would go down one pipeline, and the produced water would go down another pipeline. So it was very centralized. But we ended up buying about $150,000 of seismic and geological information and the general production information that we needed to understand Chicontepec. So we did do some geological studies as well as a result of that.
Thank you for that. I have a third question.
Yes, sir.
Which might be, I need 1 minute to explain. Answering Mr. Becker, you said that you thought there was no risk since there was a mini and a maximum amount.
Yes, sir.
Why does it suppress any risk? Why no risk? Because there is a maximum and a minimum. And if I may explain a bit, you also write at paragraph 52 of your expert report that you expected an overall return of approximate US dollars 182 million.
Yes, sir.
If Pemex requested the maximum amount.
Correct.
Did you envisage that it could not
Be the maximum.
Request the maximum?
Yes, I did. Yeah, so there is some business judgment, I guess, that you have to make as a result of that. So the first thing was we had to plan our equipment, how many rigs we were going to have, how many pumps, how many tanks, how many drilling tools, pipe, and all that we needed. And so we sized all of our equipment to be able to perform the maximum amount of work. So that decision had to be made early on, so that the maximum was $300,000 a day, and we had to have the equipment from day one to perform at the maximum. That's how we took that. And then the bond was set at the maximum, so we were prepared to do the maximum. But yes, that wasn't a guarantee that the maximum was, but the minimum was a guarantee. So for me to spend $30 million, I had to rely on the fact that work was going to come, and it would come somewhere between the minimum and the maximum.
But you had in mind that there could be nothing more than the minimum.
That was the downside case, sure. I expected more than that, but yes, you have to assume that.
Thank you very much.
If I may continue, because in the meantime, I recall a few other questions.
Just one follow-up question.
Sure.
The same question that you just asked, so I don't ask that again. But just to clarify, when on that sentence on resources, when you speak in your witness statement in paragraph 24, when you say, in my view, Pemex did not have the resources necessary to develop Chicontepec. When you say resources, you mean financial resources, or rather know-how resources, manpower, etc.?
Yeah, I really think both. There was a really gap in I told Mr. Capel and Froland Garcia both that if you go across the fence and you look in Laredo or McAllen or in the Permian Basin in Texas, instead of one company, Pemex, there would be 500 companies, and each company goes to work every day, does their little area, knows it like the back of their hand, and so it takes 100 companies, and you can't do Chicontepec with just one company, Pemex. And it's not Pemex's fault. It's just being a big company like Exxon. Exxon couldn't develop Chicontepec or much anything except Guyana, I guess. But the point is that they didn't have those resources, and really until you can understand that, to just say, here's our budget, I thought was a little bit of a disconnect.
Yes. You have been talking about the minimum and the maximum of the contracts in plural.
Yes,
but were you aware that in the first contract, 803, as far as I recall and subject to control of the parties, there was no minimum amount in the contract? It was in the 804 and 821, but not in the first one. Were you aware of that fact?
If I was, I forgot it. I thought there was a minimum, but if there's not, there's not.
Okay.
Yeah.
If someone could show paragraph 51 of your first declaration,
Okay.
Mr. Finley's first declaration. 51, yes.
Oh, 51.
My question is about understanding more how this works. You say in paragraph 51, Pemex imposed unfavorable conditions on us. For example, Pemex demanded that we return all of our equipment back to the yard between each work order. Moving the equipment between each work order is complicated and costly, and the cost is $300. What was the rationale for PEP to ask you to move the equipment between working orders?
Yeah, it was confusing to us as well. I think this refers primarily to 804, perhaps 821, and it wasn't what we contemplated. And when we made our bid and we get our fixed price, we didn't contemplate having to move the equipment back and forth. And now that I couldn't understand it either, it made no sense to us, and it just made Pemex's operation more expensive and is inefficient, even if they weren't paying for it. Just the inefficiencies made no sense to me. And I really think now that we know that the board of Pemex told them to get out of the contracts and do it at the best advantage to Pemex, I think they were just trying to run us off, maybe. It made no sense to me.
Because how far away was the yard, I presume in Costa Rica, from the rigs where you were drilling? How many kilometers or miles of distance?
I guess it could be 1 mile to 50, 60, 70 miles. But I think the real deal is, as I recall, was the quality of the roads. Raining, muddy, slow, so maybe miles isn't the best way to look at it. It's more the difficulty and the timing and the conditions that it took to go to and from the locations. This is in the jungle, I guess you'd say.
And presumably for you it was cheaper to keep the equipment in place because the different rigs and were very close to each other. So
Yeah.
rather than having to move the equipment 60 miles back to Costa Rica,
Yeah.
you could just shift it in a question of,
Yeah.
of kilometers or even
Yeah.
meters. Is
Yeah.
that the case?
Yes, and that's a standard industry practice. So Finley Resources in the U.S., if we contracted somebody to drill a well, we'd let them drill the well, and then we'd let them keep their equipment there on location until they went to their next job. That's kind of common practice.
No further question on my side. None, any cross, whatever questions. I think Mr. Becker has one. You will be given a chance later on.
First of all, I just want to correct myself from my earlier statement. There were indeed invoices in the purchase invoice of the package for Drake Mesa LLC that we sort of overlooked. There were also some continuing though from Southern Mesa Well Services back into 2013 too. But I want to correct the record. I spoke in error. It's a follow-up to your question about the overall structure of the companies. Can we put up that consolidated financial statement? Yeah, I was at R144. 145, excuse me. So these are your consolidated financial statements, which includes the year 2016.
Yeah, that's right, for Finley Production Company and subsidiaries, yeah.
Right. And then could we, I guess it's page 8. Sorry. It's R145. So here's your consolidated financial statements, and it lists the companies that are included.
Uh-huh.
And we see that it includes Finley Production Company, LP, Finley Resources, Inc., FRI Utah, Lonesome Oil, Cowtown Gathering, Panther City Pipeline, et cetera, Very colorful names, by the way.
Oh, thank you. I wish I'd have been better at naming my Wyoming and my Mexican names.
Yes. But I just want to highlight, you don't include Drake Mesa LLC.
Right,
or
those are
Southern.
separate.
Those
yeah.
are separate. Okay.
And the reason, these companies have are collateral for a bank line with Fifth Third Bank.
Okay.
At the time, yeah, I think it was Fifth Third Bank at the time. So there's a 5-bank facility. These companies are consolidated because they're included in the collateral base for that loan.
Okay, thank you. All right, that's all I have.
Any final question as a follow-up to the tribunal's questions? No.
And also,
Yes, please, Mr.
We have no questions.
Okay. So, Mr. Finley, you are dismissed as a witness.
All right, thank you very much. I appreciate it. Thank you very much. Uh-huh.
And so, probably now is the time for a break, say a 10-minute break. So, we will resume at our time at 20 to 11.
Could it be 15 minutes on the court? Could it be 15 minutes on the court?
Okay, 15 minutes. So, a quarter to 11. We will resume at a quarter to 11.
yes.
15, 1-5. So welcome back, everybody. This is one of those strange cases, like in the Tour de France, where a peloton is running ahead of schedule. I was checking, it's 10:47 against the timetable. We are well ahead of time, and we welcome Mr. Kernion in your new capacity as witness. I will ask you first to read out the witness declaration that you have in front of you. If you
change classes, I'm sorry. I solemnly declare upon my honor and considerance that I shall speak the truth, the whole truth, and nothing but the truth.
Many thanks, Mr. Kernion. So I give the floor to Clemens for direct examination.
Good morning, Mr. Kernion. Could you please introduce yourself to the tribunal?
Good morning. My name is Luis Kernion, and thank you for having me here.
So English is not your native language, but you want to testify in English, right?
I will try to do my best.
Okay. So who are you here representing?
I represent Price Permanent Holdings.
And did Price Permanent Holdings make any investments in Mexico?
Yes.
And what were those?
Well, we enter in a few contracts that I need to provide some investments in buying equipment, yards, tools, bunch of equipment required to provide the service.
And so why did you invest in Mexico?
Well, for several reasons. I got approached by several Pemex officials at that time that they were looking for U.S. exploration and production companies that had experience in operating wells. So at that time, Chicontepec, it was a big deal for Pemex. So yeah, that's why I invest in Mexico.
And what was your role in your company's, if you will, investment in Mexico?
Taking care of the operations on a daily basis.
So does that mean you were out on a drilling rig, running the drilling rig, or what does that mean?
No, not that much. I was most of the time with the Pemex officials, we monitoring the production in Chicontepec.
And do you recall how much money you invested?
The companies together, $35 million prox.
And so when you say that, you're including Mr. Finley?
Yes, Finley Resources and Price Permanent Holdings. Yes, that is correct.
Okay, so you were here yesterday, and there was some discussion about the meeting at La Aceituna, and I know this is important to you.
That is correct.
What do you remember from that meeting?
Well, I remember that Rob Casayan called me, and he told me that he's been in touch with high-rank officials in the legal department of Pemex.
And then what did he say?
Well, he invited me to go to Mexico City to attend that meeting, that probably they have a possible solution, settlement, agreement with our companies at the time.
So your intention was to go to Mexico City for a possible settlement of the disputes that you had with Pemex?
That is correct.
And when you got to the restaurant, is it a restaurant or a bar?
That was my first time. I probably both.
Okay.
I don't know.
So when you got to the place, who was there?
Well, it was Adolfo Helmond, Roberto Quesayan, and Mr.
Sorry, one more time on the first name, sir.
Robert Kiosayan, Adolfo Helmond, and Mr. Lostanao.
So when you say Mr. Lustenau, you're referring to Rodrigo Lustenau, correct?
That is correct.
Is that the same Rodrigo Lustinel that was in attendance here yesterday?
That is correct.
How long did your meeting or your interaction with Mr. Lustinel occur?
Oh, very briefly,
Do you remember what he told you?
yes.
Well, for the benefit of the tribunal, could you please tell them what he told you in Spanish?
Tus compañías están terminadas.
Your companies are terminated and you're going to lose.
What happened after that?
Well, he told me that continue the conversation with Roberto Quiosoyan, and then he left.
And did you continue the conversation with Roberto Quiosoyan?
That is correct.
And what did he tell you?
Well, he gave me the inside information, what was going on in Pemex at that time, about our litigations concerns.
Did he tell you anything else?
Yes, he was telling me. They were telling me that the board of directors sent someone to court to influence, to put pressure into the court system, into the judges for their benefit.
Did they give you a name of that person?
No, he did not.
Did you discuss anything further with Mr. Quiosoyan and Mr. Helmand?
Yes, I continued the conversation with them, and they suggest that we that probably they wanted to visit the judge with another experienced attorney.
And what was that attorney's name?
Juan José Paullada.
Was there anything else at the meeting at La Aceituna?
Well, not that I recall right now, not that I remember.
Okay, so after the meeting at La Aceituna, did anyone go visit the judge?
Well, the Roberto Quiosoyan and Juan José Paullada visit the court and the judge the following days, yes.
Were they attorneys? Let me rephrase. Were they your attorneys for that lawsuit?
At that time, no.
Did they tell you what happened at that meeting with the judge?
No, I cannot remember what happened at that meeting.
Is Juan Jose Paullada still your attorney?
No, it is not my attorney.
Why not?
Well, I hired him because he told me that after what happened, I mean, in the meeting of Aceituna, they told me that they will visit the judge, and then in the following days, we received a decision that I was told that will come, that it was against us.
Okay, I'm sorry, I asked you why is Mr. Paullada not your lawyer?
Because the board of directors of Pemex called him a few months after and invite him to be a board member of Petróleos Mexicanos.
So, and we're concluding, is there anything you've read in this arbitration that has, or heard in the past day that has bothered you?
Yes, I heard Mexico's hearing yesterday, and honestly, I found that hearing offensive for me because about the investments that we supposed we didn't do in Mexico.
Is there anything else?
Yes, that fake work orders. They want to cancel contract with the fake work order. They want to cancel $500 million contracts with something that is totally fake.
Is there anything else?
Not that I recall right now.
I'll pass the witness. Thank you.
Thank you.
Many, many thanks, Mr. Felsheimer. Now is cross-examination, Mr. Becker.
Thank you, Mr. President. Hello, Mr. Kearney, and I'm Steve Becker.
Hello, Mr. Becker.
All right, I'm going to ask you a few questions. Mr. Kearney, you were very experienced in working with Pemex, weren't you?
That is correct. Well, what do you mean experience?
All right, well, let's go to Exhibit R138. So this is a document you disclosed to us in document production. It seems to be a sort of a marketing material that describes the background of the companies in Mexico. So we see up there it describes, do you recognize this? It's on your screen right in front of you as well.
On my screen. It's part of my witness statement?
No, it's an exhibit on the record. It's a description of Drake Mesa, Mexico, in Bissell, Mexico.
Well, I'm probably this is the first time that I see this document.
All right, let's scroll down. So here's Bissell. That's your company in Mexico, correct?
That is correct.
Okay. And it says in the first line there that it's a Mexican national company with, I think that symbol's supposed to mean that with over 36 contracts successfully executed for Pemex over the last 10 years. Do you see that?
3,600. Yes.
Okay. So the contract 803 was not the first time you started doing business in Mexico, was it?
I had contract before, yes.
Okay. And let's put up, let's see, R139. Do you recognize this document? It's about the Drake Group? Scroll down.
Yes.
Okay, so you see it discusses the creation of Bissell in 2002?
Yes.
Okay, so you're there long before the opportunities for contract 803 arises, isn't that right?
Can you repeat that, please?
You're doing business in Mexico with Pemex long before contract 803, isn't that right?
Yes, that is correct.
Okay. Not including contracts 803 and 804, how many contracts did Bissell enter into with Pemex from about 2010 onwards, do you think?
I can't remember.
Could it be around 10?
I don't know.
No?
I don't know, probably. I don't know.
Okay. So on behalf of Bissell, you and your business partners signed a lot of finiquitos, didn't you?
Can you rephrase the question, please?
You completed over 35 contracts, 36 contracts or more. So you had a lot of experience with finiquitos, correct?
I know. In the way we operate, I have very skilled people taking care of those matters every day.
Okay. So your people took care of the finiquitos?
That is correct.
Okay. And your company obtained a lot of performance bonds, didn't it, for all those contracts?
Can you repeat that? Performance?
The performance guarantees, we call them performance bonds?
Yes.
For 10% of the amount of the contract?
Well, it's part of the contracts, as I understand.
Yes, exactly. So Bissell must have had equipment to perform all those contracts, didn't it?
We basically, yes, we own equipment, yes.
Okay. And did it use the storage or staging site at Tamos?
It's one of the yards that we own, yes.
Okay. Did it also use the storage site at Reynosa?
Well, I can't remember if we use how many yards we use because we hired people, very skilled people
Okay.
who manage the management operations on a daily basis. It was not part of my duties every
Understood.
day.
Understood,
Uh-huh.
thank you. Let's go to footnote 2 of your first statement. And we see up in paragraph 31, you talk about purchasing land in the town of Tamos. And then in the footnote, you say there that you use the Tamos site as security for the bond for the 803 contract. And the 803 contract is the earliest one at issue in this arbitration. Am I right to conclude that you owned the Tamos site prior to the 803 contract?
I can't remember. I don't know.
I mean, you wouldn't logically, you wouldn't have had it available to use as collateral unless you owned it, correct?
Well, we have some properties in different locations, but I can't remember if at the timing.
Okay. Which of your entities in Mexico owned the Tamos site?
I can't remember, but probably it's in the same umbrella of the companies.
Oh, you don't remember which one?
The which one? Yeah.
No, okay. All right. We're going to go to Exhibit C-159. And this is the purchase agreement between Baku and Forbes Energy to buy the land at Poza Rica. Do you recognize this?
Well, I believe it's the deeds.
Yes.
Yes.
Okay. All right. So let's go to page 44 of this exhibit. And we don't have an English translation, but conveniently you speak Spanish.
Yes.
So we're gonna ask for your cooperation if you could read the paragraph cuarta, and then we can let the interpreters translate it into English.
Por virtud de la presente
Under this agreement, the purchaser grants title to the seller. This is the right to use the real property exclusively for the seller to store the machinery and equipment that it owns, and it is now in the real estate property. And the seller is going to withdraw the machinery and the equipment for 5 years maximum, and the seller is going to take care of the property and is going to work with the maintenance of the machinery and as of the signing of this agreement. And then it says that the seller is going to facilitate to the buyer is going to facilitate the entry to the seller of the property.
So the seller is Forbes Energy, correct?
The seller is, I believe it's Forbes Energy.
Yes, exactly. So Forbes had the right to store equipment there at the site, even after selling it for some years. Is that correct?
It's something that I cannot remember, honestly.
That's what the clause says.
Yeah,
doesn't it?
but I don't know if that really happens.
Okay. But if Forbes was already storing equipment there, does that mean it had already been using the site?
Not that I remember.
No?
No, not that I remember. I mean, I can remember if.
Okay, you just can't remember.
Yeah.
Okay. All right, let's go to paragraph 9 of your second statement. All right, so here you say that Baku Exploración y Producción purchased the real property for US $3,622,745. Do you see that?
That is correct.
Okay, let's go back to the purchase agreement. This is C-159, page 43. You see the paragraph called Segunda? So this purchase agreement says that the sales price is 4,332,810 pesos. Do you see that?
That is correct.
And would you agree that translates to about 250,000 US dollars?
I can not recall the currency at that time, but around 300 probably.
Something in that range. All right, but not 3.6 million US dollars.
Well, what I referred there is Baku owns several properties for the contracts, plus all the improvements. I mean, we bought practically raw land, and all the improvements we provide to the site.
I'm sorry, I couldn't understand what you said. Could you just repeat that last line? I genuinely couldn't hear it clearly.
Oh, that we provide a lot of infrastructure to the land, to the yard,
And that was paid for by Baku?
or a company, an umbrella company probably.
Some other company,
Yeah.
you don't remember which one?
Yeah.
Okay. But when you say you purchase the land, right, let's go back to that paragraph 9. Trying to be clear here. But you said you purchased the real property. So now you're saying that includes improvements that someone made later?
Yes.
Okay. All right, let's go to paragraph 18 of your first statement. So you say here at the beginning that despite the fact that our initial capital expenditures would be significant, I believed we had a reasonable opportunity to recoup our investments and earn a profit. Right? That's what you said?
That is correct.
Okay. So you did not believe at the time you were guaranteed to make a profit. You didn't think it was a risk-free investment, did you?
Can you rephrase the question, please, Mr.
I'm saying, reflecting the fact that you said you thought you had a reasonable opportunity to make a profit, I'm just trying to confirm that you're not saying there that you thought it was a completely risk-free investment and you were guaranteed to make a huge profit.
Well, I don't know about the huge process, but I was certain that for our experience, I mean, we can perform the work according to the contracts.
Right, but you said you had a reasonable opportunity, correct?
This is in my witness statement, yes.
Okay. All right, let's go to paragraph 20 of your first statement. So in the, let's see, 1, 2, 3, 4. So in the fourth sentence, you say, as noted above, it was well known that Pemex had been exceeding the maximum values of its contracts because it was trying to increase production. Was it your view that Pemex was legally obligated to pay your companies more than the contracted amounts?
In my experience working in Mexico with Pemex, most of the time they exceeded the maximum amount of the contracts. Most of the time, yes.
Okay, but they weren't required to, were they? They were not required to exceed the amount, were they?
They were required just for the total amount of the contract, legally.
Legal, unless the contract was based on work orders, right?
But 90% of the time that never happened.
Right.
They always exceeded.
Right. And when at those times, the price of oil was very high, wasn't it?
I cannot remember the price of the oil at that time.
Okay. Based on your prior experience with Pemex that we talked about, you were already familiar with the obligation to post a performance bond for contracts, right?
Well, it's an obligation in the contract.
Right, but it's in all Pemex contracts, isn't it?
In all type of government contracts, yes.
All type, okay. So let's go to paragraph 56. of your statement. You say here towards the middle of the paragraph, you say, to secure our performance, we were again required to post a guarantee for 10% of the $55 million work obligation. This is one of the reasons why we expected Pemex to request the maximum amount of work from us. As you just said, the 10% requirement is always required, isn't it?
Required where?
In the contracts.
Most of the time, yes.
Yes, it always has to be 10% of the maximum amount, doesn't it?
That's correct.
Even when the contract has a minimum amount, correct?
I have no experience about the maximum of the minimum amount in bonds.
Or no, I'm talking about in contracts.
Well, I don't know.
You don't know about contracts that have a maximum and a minimum amount,
Well,
like your contract 804?
Most of the time, our internal attorney
Yeah.
took care of everything of these issues. I was not involved in this administration process.
Okay, fair enough. Are you aware of any contract where Pemex allowed a bond to be for less than 10% of the amount of the contract?
Not that I can remember, honestly.
Okay. Let's go to paragraph 50. And here, I mean, you can read the paragraph above if you want, but we understood that this is a discussion in relation to the contract 803. And then you discuss you said, based on my experience, I knew exactly what would happen during this process, and they would invent an issue, et cetera, and therefore you decided to sign the finiquito. Do you see that?
Yes.
So, did you have prior bad experiences with Pemex, with Pemex canceling or suspending contracts?
No, personally, but at that time, our counselor, the internal counselor, used to work for Pemex for years, and that was the advice that we got from him, from his experience in these situations.
So you followed the advice of your counsel?
That is correct.
Does Baku still exist?
As I understand, yes.
Does it still own the land at Poza Rica?
That is correct.
Why haven't you sold it?
Because we believe in permanent investments.
Are you still using it?
No, it's empty.
Okay. Now, Baku purchased the site at Poza Rica in March 2015, as we just saw in the purchase agreement, correct?
I can remember, honestly.
Do you want us to go back to the contract?
Please.
Okay. What is the Baku contract? Okay. And let's go down to towards the end, I think. Get the dates at the end. Whoops, no, because sorry, it's confusing because the contract included copies of the formation documents of the companies that were signing. It makes it much longer. Maybe it says it at the beginning. There, let's see. All right, let's scroll down a bit. Sorry for the interruption or the delay.
Signatures?
Yeah, we'll have to find the signatures.
Okay.
Go up a little bit. Let's see. There. All right, so it's. No, keep going up.
Keep one.
Up, up,
Up.
up. Okay. You know what, we don't want to waste time, we'll come back to this in a minute, we have to find the date. I know it's March, but I just don't know exactly where it is. All right. Okay, do you have access to the financial books and records of Drake Mesa, Mexico?
No,
You don't?
no,
Okay, what about Drake Finley, Mexico?
no.
You don't have access,
Well, the counties, I don't interfere in the counting.
but you could get the records if you needed them.
I have no idea right now.
Okay. What about Bissell?
We closed those companies.
You closed those companies.
Well, they're on hold.
When did you close them?
Well, I didn't close it. They're in hold. I don't know if you understand. I closed the offices.
Okay, when did you do that?
I can't remember.
Okay. Was it in 2019 or?
I can't remember.
Can't remember at all. Okay. All right, let's go to paragraph 61 of your statement, your first statement. Okay. So you take your time to review it, but I understand you saying here that you could have sued for a breach could have filed a lawsuit for the breach of contract 803 in 2013, but chose not to do that. Is that right?
Can you repeat the question, please?
I'm asking you, based on this paragraph, you're saying that you could have sued for the breach of contract 803 at this time, but instead you chose to enter into a finiquito. Is that right?
Well, that is a question for my attorney at that time. I just was following my attorney's advice.
Okay. You say, because you say here in the middle of paragraph that we could have sued Pemex, or we could have sued under the contract. Or we could have continued under the contract, excuse me. So you're saying based on the advice from your attorney, you decided not to sue?
It was, they handle those issues in the daily basis.
Okay. So let's go to the next paragraph, paragraph 62. And again, here in the third sentence, in relation to the contract 804, you say you could have sued Pemex at that time, in 2014. But again, you decided to enter into the extension. Is that right?
That's what it says,
Okay.
following my consular advisor.
Okay. Did Drake Finley, Mexico, own the same equipment and facilities as Drake Mesa, Mexico, and Bissell? Did they all share the equipment?
I don't know about that. The structure, I can't remember how the structure is.
Did they all use the same yards?
Yes.
Okay. And do you know who actually owned the equipment among the three companies?
Not exactly, but they're in the umbrellas of the Finley Resources and Price Permanent Holdings.
Right, but presumably they had purchase contracts or other lists of assets? You don't know?
I
Okay.
honestly know.
Okay. When the oil, you're of course aware, we've just been discussing, of course, continually, the huge drop in oil prices by 75% that took place in 2014-15. Did you think that would have no impact on Pemex's business or budget?
Well, that's a Pemex question, not to me.
That's not, you have no opinion on that?
Well, I mean, Pemex is aware of, of the prices all the time, right? So
you don't think a 75% price decrease is sort of extreme?
for they always take precautions, I believe.
Okay. Let's go to paragraph 85. You say here in the second sentence, this is discussing how you filed the 821 lawsuit. You said Pemex further complicated matters by challenging our lawsuit. Do you see that?
Paragraph, I'm sorry?
85. Second sentence. Pemex further complicated matters by challenging our lawsuit. Do you see that?
Yes.
Okay. Were you surprised that Pemex defended the lawsuit that you filed against it?
Can you rephrase the question, please?
You seem to be complaining that Pemex answered the lawsuit that you filed. And we heard yesterday that the lawsuits were filed, it was described as to get Pemex's attention. So I'm just asking you, were you surprised that Pemex defended itself in the court?
I believe they have to do it.
Of course, okay. But is it actually your goal just to get them to the negotiating table?
Well, at that time I was following my attorney's advice. I have no experience in these matters.
Okay. Let's go to paragraph 97. So this is where you discuss contacting Luis Gomez. And he said he confessed to you that the work order was false. That's your testimony, right?
That is correct.
Okay, let's go to paragraph 104. And then this is what you're discussing, that later you went to meet with Rodrigo Hernandez. And you say that he similarly confessed that the work order was false, right?
Fake, yes.
Okay. Now, we understand that you were overseeing the various lawsuits, isn't that right?
Not me personally, my counselors, my Mexican attorneys.
Let's go to paragraph 51 of the first statement. Yep. So you say here in the third sentence, you said, I am not a lawyer. However, I was in regular communication with our lawyers and generally understood what was transpiring. Is that right?
That is correct.
All right. So you knew that there were two lawsuits involving the Contract 821, the administrative case, I think we call it the nullity trial, and the civil lawsuit that you say was filed in Veracruz, right?
Like I said, that I am not an attorney, and for me it's so confusing to understand.
Okay.
Even if they call me and start talking to me,
All right.
it's hard to me to understand the language of the law.
All right. In the lawsuits that you had initiated involving Contract 821, why didn't you include mention of these alleged confessions of the Pemex officials? Wouldn't that have been powerful evidence to present before the Mexican courts?
I was following my counselor's advice at that time, my attorneys.
Did you tell your counselors about these confessions?
I'm sorry, Mr. Becker knows there's a thing called attorney-client privilege, and communications with someone with their attorney should not be asked directly at all.
Well, but I would tend to think, subject to the control of my colleagues, that here the question, because I was going to ask that same question myself, is the contents of your pleadings, of the group pleadings in the civil lawsuit as well as in the nullity case. I think it's a legitimate question to say whether claimants, when going to Mexican courts, plead this argument or these other arguments. So it's not internally within lawyers, within attorneys, but it's just what they told the judge who was going to write a sentence.
I believe the question was asking for the contents of a communication between Mr. Kernian and his attorney. If that was not the question, I withdraw my objection. But if it was, I maintain it.
Okay, then probably, yes, Alain.
I have a question to your attorneys. Is the internal attorneys, are they protected by such privilege? For external privilege, I have no doubt. But for internal, they're just part of the company, aren't they?
Well, Alain.
Or I suppose they got salaries exactly as any employee.
Yes, but I think to the extent that this is a very deep question that probably we can deal with later on, could you rephrase
Yes, I'll rephrase.
your own question?
Yeah, Mr. Kernian, do you acknowledge that the lawsuits didn't include those allegations?
Again, I mean, I rely on my attorneys in Mexico City.
Mhm. Okay, let's move on. Well, are we ready to go back to the purchase contract? We found the date for the Baku purchase agreement. So this is C-159, and we're going to go to page 44. So it says at the very top, or, yeah, it's talking about the March 3rd, March 13, 2015. Do you see that?
No, I don't see anything of where.
The very top, move this page up. Forgive my Spanish, but it's 13 del marzo. Del anno.
Okay, 2015.
Yes. What's that date?
13 de marzo del 2000.
March 13, 2015.
Can you?
March 13th, 2015, correct?
And what is the question?
That's the date of the contract.
Well, I don't know if that's the date of the contract or something else. I don't know. I need to read the entire document. I don't know. I haven't seen this document, honestly.
Okay, give him the document.
Page 44.
Thank you.
Mr. Kernian, you'll see 192 at the bottom right-hand corner. So that's the page here.
192.
Yeah.
Okay, Mr. Becker, which one? Which paragraph?
At the bottom right, at the page 192, on that page is discussing the date of the agreement. It runs over onto the next page.
So this document, honestly, is a little bit confusing because I can see two dates, 15 and 14.
For our purposes, it doesn't matter. I just want you to confirm that it was March of 2015.
What you are pointing there is 2015.
Okay, fair enough. Thank you very much. So as of March 2015, the finiquito for contract 803 has been signed and performance under that contract is over, correct?
I can't remember exactly.
Let's put up C74. So, okay, it says here that you met in the offices, or the representatives met in the office on February 10th, 2015, correct?
That's what the document says.
Okay. And also, as of then, contract 804 has expired under its own terms, and indeed, the finiquito for that contract was signed in April 2015. Do you recall that?
In
I'm talking about contract 804.
I don't have the document.
Okay, let's go to C24. C24 for the finiquito. And we'll go to page 9. Over here, it says here right at the top, it says that the meeting was on April 10th, 2015, correct?
Yes.
Okay. So the land was not purchased for use for contracts 803 or 804, was it? The work was already done under those contracts.
Well, it's something that I don't remember.
Okay. All right, while we're on the finiquitos, of course, as you know, in the finiquito, the parties formalize, they acknowledge the end of the contract and reserve rights they wish to reserve, correct?
Can I see the document, please?
I'm just asking you in general
Oh.
about finiquitos, right? This is the final settlement, and the parties, as part of that, can say, we reserve our rights to X, Y, and Z.
Well, that was in charge of my attorney,
Mhm.
so I don't get involved in that.
Okay. Let's go back to the finiquito for contract 803, C74, page 7. So here is the statement of the reservation of rights. And we see here up at the top paragraph that contractor, which in this case, I guess was Bissell, it holds its rights harmless in order to proceed under the law for the claim of non-recoverable expenses, as well as waiting and review times for the percentage of financing and indirect expenses. Do you see that?
That is correct.
Right, so there's no reservation of rights to sue for the being paid the balance of the contract, is there?
As I told you before, I was following our attorney's advice.
Okay, but you acknowledge that there was no reservation of rights to complain about not being paid the full amount of the contract?
Again, my experience is into oil and gas, not signing finiquitos, Mr. Vicker.
Okay. Let's look at the finiquito, back to the finiquito for 804. This is C24, page 7. All right, so then we have the representatives of the contractor saying it's holding its rights harmless regarding the acknowledgement, et cetera, of payment of the minimum 40% amount of the contract, as well as non-recovered expenses, waiting times, and the review of percentage of financing and indirect expenses. Do you see that?
Yes.
Okay. So, but this reservation of rights isn't a reservation of rights to sue for the maximum amount of the contract, is it?
Again, that's my attorney's internal job.
I understood, but you acknowledged that there was no reservation of rights to ask for the maximum amount of the contract.
That is a question for my attorney.
Okay. All right, let's go to paragraph 105 of your statement. So here's where you say that in the fall of 2018, a Mexican lawyer, Rob Kiosian, contacted me.
That is correct.
Did Mr. Kiosian just contact you out of the blue, or did you already know him?
No, out of the blue.
Completely out of the blue?
That is correct.
Okay. And how did he know you were the right person to call?
That is a question for Mr. Kyosayan.
All right. When did you hire him to represent your companies?
I did not hire
You
him.
never hired him. Okay. You discussed earlier, though, that you directed him to meet with the judge in the nullity case involving Contract 821?
He volunteered.
He volunteered. So he went in to see the judge even though he wasn't representing you?
Yes.
Do you think he represented to the judge that he was representing you?
I mean, that is a question for Mr. Kyosayan.
Okay. I need to ask you why in your witness statements you never mentioned that Mr. Kiosian went into this meeting on your behalf. Did you not remember it before?
Can you rephrase the question, please?
Yes, I'm asking you, we heard in your direct testimony for the first time, we heard you say that you attended this lunch and there was an agreement that Mr. Kiosian would go to see the court. But you didn't mention that in your written witness statements, and I'm just wondering why.
I have no idea, honestly. It happens 5 years ago, 6 years ago. I can't remember.
So you didn't remember it when you prepared your witness statements, but you remembered it today.
You start sometimes refreshing memories on time.
All right. Now, in paragraph 105 as well, you you describe Mr. Lustano as a high-level attorney. What was his position at that time?
I have no idea.
So how did you know he was a high-level attorney?
According to Rob,
Everything's coming from Rob Kiosian, correct?
that is correct.
All right. Let's go to C-127. So this is a translation of the first and last pages of Pemex's reply to the 821 contract lawsuit in the nullity case. So you can see at the top, if you scroll down a little bit, that it's presented in the name of Rodrigo Hernandez. I guess it was a senior officer or corporate employee. And then if we go down a little more, we can see in bold, there's a list of about 22 Pemex lawyers. Do you see that?
Yes.
Okay. If we scroll down a little bit more, we'll see again in bold font at the bottom that what they're saying is, court, if you want to send us any electronic messages or emails, please send them to Pauli Perito, Arturo Soto, and Odan Reveriano. Forgive my pronunciation. You see that?
Yes.
All right, let's go to the last page. Again, we see it's presented in the name of the senior official, Senor Hernandez. It's approved by Arturo Soto, and it was prepared by Pauli Perito. Do you see that?
Yes.
So, looking at this, what led you to believe that Mr. Laustenau was in charge of this lawsuit?
That is a question for my attorneys.
Okay, so you personally had no information to think that Mr. Laustenau was in charge of this case?
Yes, with what Rob Kyosayan told me.
Okay, everything's based on Rob Kiosian, correct?
What? According what?
Well, all this information about Mr. Laustenau, everything else is coming through Mr. Kiosian.
As I understand, yes.
Okay. Mr. Kernian, have you watched the recording of the Teams call between Mr. Melsheimer and Mr. Kiosian?
Briefly.
Would you agree that Mr. Kiosian said over and over and over again that he didn't recall that Mr. Losanow attended the lunch?
Not exactly.
Could you be more precise?
Can you record? Can you record the video so I can see?
Well, I don't think we want to take a full hour to watch the video, but we've identified the sections. We can move on. Now, in paragraph 107, you say here, I understand from my conversations with Rob and Rodrigo that Pemex's representative apparently met with the judge. Did you have separate conversations with Mr. Losanow where Mr. Kiosian was not present?
No.
So was this information about a Pemex representative meeting with the judge, did that come from Mr. Kiosian?
For Mr. Kosayan, yes.
Okay, so Mr. Kiosian told you that a Pemex representative had met with the judge.
That is correct.
Okay. But Mr. Losanow, you didn't have separate meetings with him, you didn't have separate calls with him?
He was having the meetings with Mr. Kosayan.
Well, you said meetings in the plural?
Well, that's what Mr. Rob Kosayan told to me.
Okay, again, everything's coming from Mr. Kiosian. Okay. Why didn't you ever hire Mr. Kiosian?
He recommended me, he and Adolfo Helmut recommend me Mr. J. Pavioada.
Right, but you seem to want Mr. Kiosian to go along to the meeting with the court, and he had all this inside information. Why wouldn't you want to hire him?
I'm sorry, but we're now recharacterizing testimony. If you clean up your question, I'll let you repeat it, but you can't rephrase what he did not testify to.
I'm rephrasing what you testified to. But let me ask you this again. Why didn't you hire Mr. Kiosian? Someone told you not to?
Not that I recall.
You just didn't think he would be helpful?
I followed the advice from Adolfo Helmut and Roberto Kosayan.
Okay. We discussed earlier that your company Bissell entered into a lot of finiquitos with Pemex around this, during this prior period, and including apparently some in the same time period as 803 and 804. Should we conclude that you were fine with the settlements for those contracts?
Can you rephrase the question, please?
You're not complaining about the finiquitos for the other contracts that Bissell had with Pemex, are you?
Which contracts are you referring?
Well, we discussed the various contracts that you had, your company Bissell had with Pemex, other than the ones that are part of this case.
Well, if I did not complain, it's because Pemex pay.
All right, Mr. Kernian, as you know, Corporación Estratégica Pixiu is the partial owner of both Royal Shale Holdings and Royal Shale Corporation. Who's the ultimate beneficial owner of that company?
Can I see the document, please? I can't remember.
Okay, let's go to C-150, page 2. So it's the half owner.
Yes.
Yes. Who owns that company, Pixiu?
Mr. Margain Wendorf.
I'm sorry, who?
Mr. Margain Wendorf.
Would you mind spelling that?
M-A-I-G-N. Wendorf. Wendorf. W-E-N-D-O-F.
Oh, Mr. Wendorf. Okay. All right. Well, thank you for that. Can I have one moment?
La primera, la de arriba.
This was C-150,
Yeah.
and it's also what's the other one? It's also the
C-160.
safety, yeah, put up C-160, page 2. Mr. President, that's all of our questions for now.
Okay.
Mr. Kernigan, thank you very much.
Thank you.
Any redirect? Focus on questions raised by respondent, Mr. Becker.
No, sir.
Then Alain and Franz, you want to start, Alain?
I don't care. Well, I have some questions in this order. At paragraph 107 of your statement, you were told, I understand that you were told by Mr. Keosayan, it is not what it's written, but it is your answer to Mr. Becker, that Pemex's representatives visited the judges on your case. Were you shocked with this news?
I was extremely shocked.
And if so, why did you send Mr. Keosayans do the same?
Well, he volunteered. He wanted to go because I was so in shock, and because when they called me to that meeting, I was expecting a settlement, not that they approached the judge to influence the judge and pressure the judge to help Pemex.
But, well, I will go back to the questions I was forbidden by my president on the internal attorneys. You seem to be extremely confident to your attorneys, which I think is very dangerous. People should not be confident in attorneys, but you seem to be. So really, I would like to understand why. You may answer later, because the President mind this question being discussed now, but I really insist that I want to understand why their internal attorneys would be privileged. When you are an internal attorney, you get a salary. This is a remark for both parties. I am sure that Mr. Kenyon will say, not my problem, but my attorneys.
I'm not sure whether he was speaking about internal attorneys. I'm not so sure whether he was talking about internal attorney or external.
Then this is my
counsel.
question for you. When you say, I am confident in my attorneys, you said this several times, answering Mr. Becker's. Do you have in mind your people in your companies or external attorneys?
Can you rephrase the question? I'm lost a little bit in your question.
Well, you answering the questions, you said again and again, not my problem, I was confident in my attorneys. These attorneys were internal attorneys or external?
External, sir.
All of them?
All of them.
And every time you had these questions, you signed a contract or you were finiquito, you resorted to external attorneys?
Well, taking care of the 803, 804, and 821, they were external. But I have an internal attorney, local attorney, who handles the administration contracts, just to clarify that.
Okay, thank you. Now I am more clear about that. I have some other. well, this might be more a concluding question, but I have been in mind. You said that you believe in permanent investments. Is this still true in Mexico?
And that
Do you
is
still believe that in permanent investments in Mexico?
that is correct, sir.
You still. And you have other permanent investments than those contracts 803, 804, 821.
That is correct, sir.
Okay. So when you say, I still believe in permanent investments, do you have in mind these other investments or these ones?
Overall, sir. Overall. I mean,
Including these ones?
Which ones in concrete?
The one we are discussing, 803, 804, 821.
Well, sir, we invest a lot of money in those contracts. A lot of money. Practically all my company invest every single cent, all the cash, everything that we got, were invested in these 3 contracts. We have a commitment, $500 million with B. So that requires vast sums of investment, sacrifice. You have to put your heart, your knowledge, your everything you got to perform those contracts, sir.
Okay, so you in your mind they are still valid?
Definitely, sir.
Good.
It's part of the way we think. Long-term investments.
Okay. Except I can understand this for 821. For the 2 others, they were not long-term, were they?
What I mean is when we went to Mexico to perform these contracts, I have a commitment with Pemex officials to be there for a long time, period of time, for very extensive time. That's why we imported all the equipment, permanent. You have 2 options, as I understand, and I'm not an attorney. You have 2 options to bring equipment to Mexico. It's temporary and permanent. So Finley Resources and Price Permanent decide to go permanent, to go there, establish there. They requested help. They were bleeding for help for international companies. We went there. We invested all we have to perform $500 million contracts.
Okay. Well, this takes me to my last or penultimate question, I don't know. You write at the very beginning of your written statement, I think it's paragraph 8, if I can reread me, but I'm not sure. Despite significant expenditures, I believe we had a reasonable opportunity to make profit. And in that I join a question which was asked by Mr. Becker, but if you could elaborate a little bit more. My question is, did you do any other due diligence than the fact that you had experience with this? You said, and you explained that you had previous experience with Mexico, and apparently I understood that this was really the reason why you you believed, you were optimistic about the effectiveness of your investments.
That is correct, sir.
So, and no other due diligence? No studies, general economic studies or financial studies?
You mean personally?
Not personal, but from your companies.
Well, we had experience in working in the midstream and oil and gas services, work with Bizel until we get into these contracts, which is more complicated contracts that required. It was a different, totally type of work.
And these were the same reasons which made made you believe that the maximum would be reached or exceeded.
Definitely. When I was with the Pemex officials, we always talked. We never talked about, right now I can hear 803, 804, 821, but when I was with them, it was just one umbrella. It was $500 million that we needed to perform, that we needed to act fast, and that happened in a very short time. So my partner, Finley Resources and Price Permanent Holdings, did whatever it was in our with a lot of efforts and with a lot of pressure, because timing was running out. Pemex required a lot of we were the first responders, let's put it this way. Pemex did a lot of travels traveling, asking for help for a lot of international companies, exploration and production companies, and we were the first responders. And as I understand, we were probably the only ones with that experience that Mr. Finley and Finley Resources had. We brought, my partner is here, not only an honest person, we bought one of the best operators companies in the U.S., Mr. Finley's companies.
Okay. My last question will be on Mr. Keohasian, which is omnipresent in this room. What Mr. Becker also asks, why? I think when I read your paragraph 105, I also wrote why. Why did he contact you in fall 2018? And then listening to you, and then reading your second statement at paragraph 11, you write that Rob Keohasian seems to have taken the initiative of the, I don't remember, Al Casene, the restaurant or bar in Mexico City. And I wrote again, why? Your answer is, ask Mr. Keohasian. That's for us a bit difficult now. But my question is really to you. You never wondered why he was so helpful for you?
Well, it's my experience in Mexico. There is a lot of people who provide lobbying, and as Mr. Keohasian introduced himself with me, he was a lobbyist that apparently at that time, I'm talking about what he told me as his introduction, right? That he was kind of the middle person between conflicts in Pemex and the company who requires the service in Pemex. So practically he knows, or there is a people who knows that when there is a conflict, they approach to trying to settle, to trying to work something. But he introduced himself that he advised Pemex legal department. That was his introduction to me.
But lobbyists are paid. No, yeah, it went out. Lobbyists are paid. Did he ask for any payment, or did he, because you don't lobby just for the sake of being pleasant?
I did not pay anything to Mr. Keohasian.
And you think he was paid to lobby you?
Well, he wanted me to hire, but recording the level of the case, he and Mr. Adolfo Helmond recommend me a higher level very recognized attorney, which is JJ Pavllada, which now is in the board of Pemex.
Thank you very much.
Thanks, sir.
If I would be able to direct you to your witness statement paragraph 61, I think Mr. Becker had also a question in that regard. You have in the fourth line, you say, in relation to the 803 contracts, you say, as explained above, I was in contact with Pemex officials who told me not to worry about the work stoppage. Can you be a bit more particular in that regard, if you still have the memory as to who you were speaking to, when exactly, and what precisely was said? Or you don't have a particular memory anymore, and whatever you remember is just what you wrote down?
Yes, I was in contact with the people in charge at that time is Guadalupe Lopez. They call it Pepe Lopez. He was in charge of this department.
Okay, and you remember more or less the time? Where, was it several meetings, or was it just one meeting?
Well, that Pepe Lopez was on the high rank official that I was in a weekly basis in contact with him, because that was it's when you decide which areas you have to go. So, and he was in charge in that department. So he's the one that practically delivers all the work orders.
And that was, but what prompted that particular meeting when you asked him or when he apparently made promises, was that in connection with the extension that Pemex sought, or did you have this kind of promises before? Was that in the connection with the extension that he said, please stay in?
Let me go back.
If you read from the beginning, if you read that paragraph, understand the triggering of your discussion with him.
Yeah, they out of the blue, without any knowledge, they suddenly flipped the light.
Mm-hmm.
They stopped the work in that department. So I was worried, because we have a lot of millions of dollars sitting in the in standby, doing nothing, and I was worried. And he says, "Don't worry, this is a budget issues that we have to fix first." Says, and I told him, the budget issues, I mean, should be not the issue, because when we started the contract, we already have the budget. The budget is attached to everything. We don't have to have these issues. Said, no, this is temporary. Don't worry, it's gonna be temporary, only probably a week, 2 weeks, and it took forever.
Did he mention, because you further down, you have the same issue in relation to 804 contract. You mentioned that in paragraph 62, right?
Well, the 804 was worst.
Was that another meeting, or was it was a subsequent meeting, I would imagine?
Well, I believe 804, it was a different person, probably.
Yeah. Would you recall who, or you didn't?
I can't remember, because it was a very difficult time. They changed officials at that time. It was the rotation in Pemex was kind of happening at that time. A lot of rotations. I can't remember, but I remember the basics, what happened in 804.
But in relation to 804, early 2014, what were you told there? Were you told something similar, or were you just building on the expectations that you had received or you had formed earlier on in October?
At that time, it was confusing everywhere in Pemex. So it was not they were not organized. That's the truth. It was a lot of mixed information, but everything it was related and attached for budget issues. Mm-hmm. In the 804, we signed the contract. They waited I heard yesterday, with respect, that we failed something. I don't recall that we failed anything. We were ready. We were there. We received, after I don't know how many months, I received 2 work orders. We mobilized equipment, which, just to start a contract, Mr. Franz, requires vast sums of money, vast sums of equipment. It's not something that appear. The people who is involved in this industry knows that this industry is extremely expensive. And we received 2 work orders in 804. Same time we were ready to drill. We spent probably $1 million just to mobilize the equipment. We were ready, and out of the blue, I cannot remember, and I cannot be precise, for a week and a half or 2 weeks, we received a document saying, you know, oops, I am so sorry, rig down and go back to the yard. That's what I faced, because I was there. That was part of my job.
What was the basis for your expectation, and that relates back again to the paragraph 61, where you say, based on the representations to me and in the contract, we continue to believe that Pemex would act in good faith and request at least 55 million under the contract. Apart from your reading of the contract, which was a topic of examination, were you given any kind of expectation, was there a direct representation that you would reach that maximum?
Yes, I just was following our conversations with the officials, with Pepe Lopez, in that contract, 803, with Guadalupe Lopez, and he was telling me, don't worry, we're going to extend the contracts and we will contribute with extensions of the money and everything that you are expending right now, all the, you know what I mean, all the standbys, basically. In the contract, Mr. Franz, in Pemex, sometimes you sign a contract and there is a different concepts, right? But not any contract, when you are performing, you are missing several concepts. So when you are already performing the contract, something happened out of the blue that you have to do. You have to act fast. And you are not gonna wait until the board of directors from Pemex authorize X or Y. You work, and at the same time, you add those concepts into the contract to get paid. It's a simple process, nothing complicated. It's very simple. You already have the contract. So at that time, when we were in standby, we already have in that contract in 21 a daily rate. So they should pay the daily rate, but they were missing other things that I cannot remember.
Did you tell these representatives when you were talking to them, Guadalupe Lopez, what your expectations were as to what was the profit that you were expecting, or whether you were expecting at least to be covered on the daily rate? Did you tell them what were your expectations or not? Was there that an issue or not?
To perform the contract, the maximum amount of the contract.
That you said to them?
Of course. Of course.
So the conversation was about that, about your expectation, as you just now say.
And actually, in that contract, there is a little bit. We started with X amount of equipment. I can't remember, 3 or 4 rigs. And when everything started perfectly, and in the middle of the road, let's put it this way, they request more rigs. We were not in the contract. So that's why we decide, I talked with my partner, Finley Resources, and Jim, and we bought more equipment for his request. So, and he told me, bring more equipment because we have the necessities right now. We were bleeding. At that time, they needed to work over 13,000 wells, as I recall. 13,000 wells. in the Chicontepec area. So they needed a lot of help with few people. And other thing that is important is regarding the Mexico's hearing yesterday. They were not requesting at that time service companies. They were requesting operators, U.S. operators. They needed to know, because there were, I was there, Carlos Morales, who at that time was the director, one of the highest rank, probably number 2 in Pemex. And he told me, I don't want the Four Sisters. They call it the Four Sisters. Halliburton, Weatherford, Baker Hughes, you name it. We need real operators. And that's my partner, Mr. Finley, and his team. They're the best. So that's why they required 13,000 wells. They required to act fast. My expectation, if you see the documents, the total budget that project had, it was more than 40-something million dollars. I think the government budgeted between 80 and 90 million dollars. That project, that contract. So I was expecting the maximum amount and more, because that was the promise they told me.
Thank you.
Mr. Kernin, I have a few questions for you. The first one concerns, is a follow-up to a previous one on the famous La Aceituna lunch. Because let me check with you whether I have understood well the entire development of the lunch. The meeting, the lunch was called by Mr. Keoseyan, who suggested to you that there was a possibility for a settlement, and he signaled that he was acting, according to you, as a representative or someone, an intermediary, but with close connections with Pemex. So, and you arrived in the lunch, you told us, expecting the possibility of a settlement. But then, if I understand your recollection, while in the lunch, you were told your companies are done, so there is no possibility of settlement, you are going to lose. And so, is that understanding that I've just expressed correct, that there was some big surprise, that you thought that you were coming to a meeting to negotiate a settlement, and you were said that you were going to be defeated, and that Mr. Lustenau told you that they were going to not to pay, and they were going to get a favorable ruling?
That is correct, sir.
So
yeah, that is correct.
The meeting was called by Mr. Keoseyan as a sort of informal intermediary with some connections with Pemex.
He introduced himself as a, let's put it this way, as a middleman between Pemex and in that case, with me.
Yes. And to that extent, you didn't feel the need to pay him anything, as Mr. Pelé said, because he was acting as an intermediary and with links to Pemex. Probably you thought that it was Pemex person rather than an independent intermediary.
That is correct. Well, at the end, as he introduced himself as a middle person between Pemex and the companies, and if they succeed in something, probably they will charge something, right? But in this case, nothing happened.
Okay. And then you have spoken many times about your attorneys. You had at least one in-house counsel, and you also used or hired outside counsel, including at the very end, I understand, Mr. Paullada. Could you tell us who the in-house counsel you were relying on was, and who were the other outside counsels that you were using for your work in Mexico?
Yes, sir. The inside house, his name was Mr. Fermin, Fermin Arias. He used to work, he retired from Pemex in the Chicontepec area. He worked there, I don't know how many years, honestly, I will lie to you, sir. But he worked there for 8 years, Fermin Arias, and he worked in the contract department. And he stepped down or retired or something happened, and so I hired him to guide us in the contracts, because there is a lot of work, Mr. President. When you are performing these types of work, requires Pemex has a lot of locations. They're spread with a lot of departments, and in every single department we have to have people to work together to process the works, to process all the administration paperwork. So that required to follow the contract, and you need to hire expertise to know that work.
Yes, but to be more specific and focus the issue, my question is, I was meaning from the moment when you decided, or the group decided, that you had to litigate. And my question is, once you decided that you had to litigate in Mexico, who were the key lawyers, attorneys, calling the shots and devising the strategy for your group, for you and for Jim Finley?
We hired an attorney that her name is Cristina Vizcaíno.
And when did Mr. Paullada was hired?
Well, when we started the contract, I mean, what I recollect in my memory, back again, I was trying to, I work in the oil and gas. For me, having all these legal issues, it was a big problem for me, because at the end, I'm not a player. We are not a player in that game, in that field, right? So we hired Cristina Vizcaíno, and Cristina Vizcaíno started taking care of our cases, civil cases. But then, as I understand, something happened that has to be with the administration courts, and so it's kind of a different expertise in legally, as I understand. So Christine at one point told me, we need to get advice from experts in this area. So I just was trying to follow, but it was not only Mr. Paullada. Probably we hire another counselor that I cannot remember, honestly, because the head was Cristina, and at the end, Mr. Paullada was taking care of everything, all the cases.
Yes, but I read somewhere that Mr. Paullada was an expert in tax law. Is that the case?
Yes, sir.
So he was not a litigator.
Well, as he told me, he has a kind of experience in the federal administration courts, which is the tax law over there. I don't know if this is correct or not.
Yes.
But he has a personally, but at the end he has is a big law firm, so he has a lot of expertise around him, and as I understand, he was a minister of something at one point in Mexico, appointed by the president. So he knows the system. Let's put it this way, the legal system. So that's why we hire him as a expert.
Yes, and then to be more specific, for instance, in the contract 8-1, you had an arbitration clause, but you decided, well, the investors decided to go to the Mexican courts. So you make that call, and in the end, the outcome was not particularly favorable to you. So my question is, who decided that you would then use the arbitration clause and go to the ICC with a Mexican seat, and you rather went to the Mexican courts for the civil lawsuit in the contract 8-1?
You mean when I was in Mexico litigating?
Yes, but before litigating in Mexico for the civil lawsuit for contract 8-1, you didn't use the possibility of arbitrating the case in an ICC case, because there was an arbitration clause in the contract which you didn't use. Later on, Mexico accepted to participate in the legal proceedings, and then that created down the road some problems. But at the beginning, someone within the investors group decided that you were not going to resort to arbitration, but rather go and present and lodge a civil lawsuit in Mexico. And my question is, who made that decision? Who made that call?
Well, the first time I heard arbitration is when I started conversations with Holland and Knight. At that time, honestly, I was relying. I did not was aware that we have X or Y in our contracts. I was relying in our
Sí, pero eso es rescisión. Pero yo me estaba al sitio. Okay. But why are you asking this? Because there is an underlying issue here, which I will present openly, because claimants in this case are presenting their case as a case of denial of justice by the Mexican government, Pemex, but also the Mexican judiciary. And by making the case rest on denial of justice, you are implicitly assuming that your advocacy in Mexican courts was a strong one. And if I may use a soccer metaphor, so there was a match between you and Pemex. You lost, and there are two possibilities. Why did you lose? The first one is, and that's the claimants, because the referee was not fair and did a poor job, and just didn't call a penalty when there was one, etc. But there is another possibility: is that your players didn't play well, and you were defeated not because the referee was denying justice, but because you didn't choose the right lawyer and the right litigators, and you lost. Let me give you one example of why I was thinking along those lines. When it comes to the civil lawsuit, and my apologies because I know that you are not a lawyer, but at someone we need to put the question to someone, and you are the only witness. And my understanding is legal experts didn't went into the detail of the contracts and legal proceedings. For instance, in the ruling in the civil law case on April 2nd, 2019, the Mexican tribunal makes a case, argues that your lawyers, your attorneys, didn't do a good work. If you allow me to read the sentence in Spanish on page 131 of the ruling. By the way, the document is JAH, one annex to the legal expert, one of the legal experts, and probably is in another document. But for instance, in the central paragraph of page 131 of JAH 32, it says, the court.
However, we do not see that there is any statement or evidence for the statements or the amounts, and therefore there should be a decision along those lines and sunken costs, since in the original pleading it is stated that it should be taken in the enforcement of the decision, and there is no basis for that.
33 of the same document, the court says, por ende,
Therefore, it would not be feasible to have a generic decision so that by means of a remedy, the full amount should be shown, since that is only whenever damages are claimed under Article 353 of the Code.
You didn't supply the court with enough detail of the amounts you were claiming, because you expected that once you get a favorable declaratory sentence in the execution phase of the sentence, then you could specify and spell out the specific amounts. So here the court is criticizing essentially the approach taken by your attorneys. The question is, to what extent is that right, that your attorneys did a good work as litigators in this civil lawsuit? Then, when I come to the nullity case, the administrative process, the ruling, the 4th of October 2018, is a very long sentence, but it runs into 230 pages. Is Art said 39. It's 250 pages, but I realize that the first 160 pages are devoted to the question of how the work order was notified to the contractor, which makes clear that a significant part of what you pled in this case had to do with how the work order, the famous work order 28, was notified. And probably that was the focus of your lawsuit, administrative lawsuit, in this nullity case, and the sentence didn't discuss in detail other issues. It does a few more, but out of 250 pages, 160 are focused on the question of the notification. And this brings me to one question raised to you by Mr. Becker, is to what extent in the nullity case, in the administrative case, which was decided on 4th October 2018, you raised the question of this fake work order. Did you represent to the court ruling on this case that the work order 28 was a fake one? Because that was a very relevant question, and by reading the sentence, I didn't get any impression that you had made that specific point in your pleadings, that work order was fake. Again, it's a very technical issue, but it's very important. I don't know whether you are going to be able to answer it, but it's for everybody to know that that's something which I find relevant in deciding this case.
Well, when I recall, Mr. President, I cannot remember exactly the details what we apply. I relied that into our attorneys, but for me it was very clear that that also we had that 15 work orders were missing to cancel the contract, not one, 15. So I don't know. Probably.
Yes, no, I know, and that's one of the points your counsel have making, that
yes.
The clause R rather than X, etc.
But
no, but I was asking to what extent you are sure that the behavior of your litigators in Mexico against Pemex did a sterling job, and so they did their best, but unfortunately, because of the denial of justice, you lost. So you lost the match, and you're saying because the court system, the referee, didn't live up to the pledges under the NAFTA treaty. But another possibility is that your lawyers, either Mr. Paullada or Mr. Vizcaíno or whoever, Mrs. Vizcaíno or whoever, didn't do a good job, and you lost because you don't made your case compelling enough for the judicial system in Mexico to grant your requests?
My feeling, this is a personal feeling, Mr. Manuel, Mr. President, is that it's very difficult to go against a government company. They have all the credentials. You can hire the best attorneys. You can spend whatever you want to spend. They are going to send someone, probably the referee, and you're done. It doesn't matter. I cannot tell you with my experience if my attorneys did a good job or bad job, but my personal feeling, what I face in these 10 years, Mr. President, 10 years, I've been struggling, and still, probably I did some mistakes, yes, probably. It's not my, it's not my cancha, it's not my field. I try to do my best. But in this case in particular, I can see the government behind of everything. Mr. President, it's $500 million. They told me at one point it was the third biggest problem, liability for the board of Pemex when we filed these litigations in Mexico. Number 3. They did whatever they did whatever they needed to do. And if you put something in perspective, one fake order that is $1 million, and they add something else that doesn't reach $800,000, they want to get rid of $500 million contract. I mean, my resources are not the same resources to defend myself to Mexico. And I'm glad that Mr. Bonfilio said something yesterday. I'm glad that he mentioned it, that this is the first case of NAFTA, I believe. I'm not an expert. NAFTA?
No. USMCA.
Or USMCA. I mean, I'm sorry. I mean, I don't know which one. I'm glad that we're in this position right now, because this is the best example of honest, very honest case. If I did mistakes, probably, because with law or this, or if I apply this, good or bad, whatever, we invested the money, sir. We were there. Until today, they're pumping what we did. 400 plus wells. We drill 26, 25 wells. They're producing. We do it 100 something frackings. So they're producing our the wells right now from the past 10 years. And what is my payment? The recollection of the bond for $48 million. So how can I defend myself, Mr. President?
Well, another general question is, I asked this question to your colleague, Mr. Finley, is something which I have been missing in this arbitration from the beginning is a very nice organizational chart, as typically you get, and I drew it myself with the different players. At the very top, there are 3 U.S. companies, including yours, Price, and then the different subsidiaries and the cross shareholdings and the like. Could you give us your own interpretation of how the entire group of investors, of claimants, including Price and the 2 companies of Mr. the 2 companies in which Mr. Finley is a significant shareholder, are organized, including the subsidiaries?
Well, I can only rephrase or talk about the umbrellas, the holdings, which is Finley Resources and Price, because the structure down, I will say something that is not correct. But we put together that present. You're talking about the presentation, right?
Yes, yes. Well, in the latest submission, I think your lawyers have been producing some charts, but the partial charts of some companies, not of the overall picture. But to be more specific, for instance, in some cases, you claim that you have control of a company in which you have only a 50% share, not a 51%. And on what basis do you have control of companies in which you don't have a majority of the capital? For instance, in Bissell, if I'm not wrong, you have 50% of...
No, sir. The chart they showed, it was it was an old one. The new company structure, I own the majority of Bissell.
I see. Okay.
Or right. Price, I'm sorry. Price owns the majority.
Yes.
Excuse me, I hate to interrupt. Is there an exhibit number for that updated structure?
I believe so. I really don't know what we're talking about. If we could bring some, I appreciate we're talking about organizational structures, but it would be good to see some things to be able to answer the question.
Yes, probably at some point we might consider whether that would be good for the tribunal to have a overall picture of the shareholding connections. For instance, Finley Resources, as far as I read the papers, have a just 10% stake in Direct Finley, Mexico, whereas Price, meaning yourself, have a 80% stake in Direct Finley. So that type of interconnection. Later on, new companies have appeared, including Royal Shell Holdings, which had a 25% of. So we have got separate pieces of the shareholding structure, but not an overall clear picture as you typically get as an arbitrator on the very first stage of any investment arbitration case. But anyway.
On my understanding, we control, Price controls and own the majority of Bissell. Yes.
Okay, fine. Then I have just two final questions concerning your own first statement. The first one is paragraph 80, in which you say something that Mr. Finley also stated in his declaration. It's about this question of that Pemex imposed conditions that made it more difficult for us to perform. Instead of moving our equipment from one job site to the next, Pemex demanded that we return all of our equipment back to the yard between each work order. What was the reason for that? Just purely a punishment, or was there any rationale for Pemex to do that?
Budget. They were struggling in payments, budget. So, believe me, it is not a good picture, that you finish a job and then you get raked down and go back to the yard. It is not something nice.
But why was that a budget issue? Because for Pemex it was the same.
No, Pemex budget issues. I mean, the contract says that when you finished a job, you have to go to the next one right away. And most of the time, how they work in the Chicontepec area, in that area is if you go in a macro path. We call it macro path. It's a path. And in that path, you have several wells or several locations that you have to drill. So for us, moving to the next location is just moving 20 meters next.
Yes.
But imagine, rig down, and probably every single time we truck to a location is like 35 to 37 trucks, full trucks of equipment. That requires a vast logistics and money to go back to the yard. So the risk for Pemex benefits and for us benefits is just to move 20 meters next door and drill the next one. But no, go back and stand by, because we have they have, Pemex has budget issues, which it's crazy because we already have the budget attached into the contracts. That is not an excuse. Remember,
But I'm sorry, because I'm a bit slow. Why did the fact that you had to bring the equipment back to the yard reduce the expenditure for Pemex?
Because at the end, they have to pay transportation or some kind of transportation.
Or is it perhaps what Mr. Conte asks is, they just asked you to go back to the yard because they didn't have the budget for you to go drill in the next one. It's not that Pemex would have to pay if you are not on a drill site. It's just that they didn't have an opportunity for you to drill. That's why they said go back to the yard until we have budget, and we'll ask you and give you a work order for the next one.
That is correct.
Is that your explanation?
That is correct.
Which brings me to my second and probably last question to you. Is on paragraph 82, in which you use in which you say on the third and fourth line, Pemex then told us that it was suspending the contract. And actually yesterday, you may recall that in Mexico's opening statement, Mr. Arteaga used the word also suspending the works. And my question is, this is a legal question, but when here you are talking about suspending the contracts, you mean suspending the contracts in the contractual sense that the relevant clause 17, if I'm not wrong.
In which contract, Mr. President?
A21. I think there's a specific clause regulating the cases of suspensions, in which imposes some obligations on the part of Pemex. My question is, to what extent there were de facto suspensions, which were very much suspensions of work, which nonetheless were not subject to the contractual clause dealing with suspensions, and which impose on Pemex obligations. My question is, was Pemex imposing de facto suspensions without meeting the conditions in the contract envisaged for suspensions? For instance, one of the clauses in the contract says that the period between one work order and the next shall not be considered suspension. So which opens the door for de facto suspension. So you don't issue a work order, and then you rely, as Mr. Gomez said in one memo, between that time you don't have any work, but it's not technically a suspension. And I was wondering whether here on page, in paragraph 82, you were referring to suspending in the common usage of the word. Suspend is to delay, or not, rather than the contractual sense of declaring a suspension. This is a legal issue which I will raise with your legal expert. But I just wanted to know whether here you were using the word suspension in a technical or in a general sense.
Can you
paragraph 82.
82. Okay, hold on. Give me just.
It's line 3 and 4. Pemex then told us that it was suspending the contracts. And to be more precise, was Pemex telling you that they were invoking clause 17, or that they would be stopping issuing work orders?
Well, that's a good question, Mr. President. I recall that. In January 2016, Pemex told me, very specific, that they're not going to give any more work orders, that they're going to suspend the work orders, and they wanted to cancel the contract. That was in January 2016. That's my comment. So I approached to several officials at that time to confirm, because you know it's different departments, a lot of people working in Pemex, and they confirmed that they wanted to cancel the contract, that they will not issue any more work orders. January 2016, in the 821 contract.
So they told you here that they were suspending, in the contractual sense of the word, and eventually canceling early the contract.
That is correct.
With the application of the legal provisions. Then, to the extent that they haven't reached the minimum amount, you decided a few months later on to not to go to arbitration, but to present civil lawsuits in Mexico.
Well, after that the meeting with officials in January 2016 and what happened with the 803 and 804, I mean, I do not need a magic ball to understand that they are following the same process, that the same pattern, you know. They told me the same thing in the 803 and they did the opposite. They told me the same thing in the 804 and they did the opposite. They're telling me the same thing in the 821. I mean, for me, okay, I think I had experience now that is going to happen, and that happened because it completely stopped the work until a miracle occurred, and they suddenly, out of the blue, they issue a work order 11 months later. Totally fake work order.
And the decision in April 2016 to present a lawsuit in Mexico was your and Jim's decision, or was on the advice of Mr. Paullada? Or?
No, with Mr. Paullada was not at that time. But let me tell you, I was trying, believe me, the last thing that I wanted to do is to litigate with Mexico, litigate with Pemex. That's not my job. Our job is not to sign finiquitos, Mr. President. Not to sign, I mean, we want to sign contracts. We need to sign blocks. We want to produce oil and gas. Not. So I approached them and they told me, you know something, Luis, there is no other way that you can get your money back. The only way that you need to put your money back is you need to file a lawsuit against us, because that's the only way that we have to pay you. We need an excuse to pay you, and that excuse is you have to follow the process and start a litigation, which for me was, oh my gosh, I mean, so I don't have options. You already have 35 millions on the bucket. I have the pressure, because the last thing that you want to do in this business, Mr. President, is to have a bad reputation with your partner, especially when your partner is Mr. Finley. You don't want to have that reputation. So I was in the corner, what to do? How I'm going to deal with Mr. Finley now?
Yes, and am I right in speculating that the lawsuit in April 2016 was meant mostly as a warning shot to give you leverage to negotiate with Pemex? Because and that might explain why, rather than go the ICC route of an arbitration, you just lodged a civil lawsuit in Mexico, because it was not meant as a serious lawsuit, but just as a bargaining tool to negotiate with Pemex.
Again, I mean, I was the advice from Pemex even. They told me, you know, that's the only way that we can pay you. So for me it was, you know, something that I need to do right away. And I wanted to do it fast and you know, because we were bleeding money. We were burning money. It was a very desperate position that we were at that time.
Okay.
Since we are just on that topic, and I think Mr. Becker also asked about that paragraph 85 of your witness statement, the first one.
Paragraph what?
85.
85?
You were asked about the second sentence. I'm curious about the first sentence. And following up on the chairman's question as to whether the initiation of the local lawsuit was sort of a way to create a bargaining chip, Then here you say, in response to a lawsuit, Pemex officials from the Contract and Labor Department told us that it would not pay us anything while our lawsuit remained pending. My first question to you, again, can you recall who told you that? If you can't, you can't. And the second thing is whether that statement that you say here, this representation made by Pemex officials, was made within what Mr. Conte says is possibly a sort of a negotiation, and it sort of, you filed and then they said, well, we'll only pay you if you withdraw this lawsuit.
Well, what I meant there is when you file something, there's still some invoices pending. So if you file the lawsuit, everything stopped. So I'm not going to get paid the invoices that are in process, because I'm focusing in the big picture, right? So that's what I meant there. That okay, you need to understand that the following or the invoice that are pending probably to get paid or something, that's not going to happen. But in this case, when we filed these lawsuits, we signed the finiquito, so they stopped the work order, and I can't remember if we have some other little issues like pending to get paid.
But from when I just hear you, it seems to me that rather what you say is that was the natural result, that if you sue, you're not going to get paid, or the other party will hold back with the payment. That's something else that would say here that there was an express representation made to you that they will not pay. What is it now? Which of both? Did you receive an express representation that they would not pay as long as you would have that lawsuit pending, or was that something that was just a natural consequence of you suing?
I cannot understand quite the question.
Okay, my question is, you state here that you were told by Pemex officials, and perhaps you want to read that sentence, from the Contract and Legal Department, that Pemex would not pay us anything while our lawsuit remained pending.
Yes, well,
Then my question is, did you receive any such kind of statement? Did you hear something? If so, if you recall, by whom? Or was the non-payment just a natural consequence? If you sue somebody, he's going to be a bit more reluctant to pay you. Well, and you have perhaps a sort of a bargaining situation, as Mr. Conte.
Well,
indicated.
as I mentioned, in Pemex they have a different departments, and believe me, with all due respect, they're not connected.
Yeah.
So the legal department is one, and the contract department is another one. So they have a different department. So what I meant here is the legal department says that, you are not going to get paid until you don't withdraw these lawsuits, or until these lawsuits get. But the other department says, well, this is the only way that you can get paid. So you have multiple, mentalities inside Pemex. So one says you do this to get paid, and the other one says, no, we're not going to do that. So it's complicated. And again, this is not my field, Mr. Franz. It's something that probably I tried to do my best, and I was there, or we were there, to perform, not to fight. We were there friendly.
Yes, but that's, if I may, on that same paragraph, there is a sentence which you could consider somewhat naive. It says, Pemex further complicated matters by challenging our lawsuit. So, as respondent has become in this case, they exercise their legal rights under the Mexican legal system. So here you seem to think that you didn't expect Mexico and Pemex to fight your lawsuit. And that's why you say Pemex further complicated matters by challenging our lawsuit. What could you expect?
In which part, just to clarify that.
Paragraph 85, is the second sentence, second line.
Well, yes.
Because the first part, the first sentence is an illegal behavior on the part of Pemex. They suspended work orders as a retaliation. But the second sentence, I think, is somewhat naive because Pemex naturally would fight you off in the Mexican courts.
Yes. Well, our intention at the beginning was to file, to get the attention, but before that, we have an option. They call it órgano interno de control, something like that. That is it's an agency inside Pemex that is like kind of a mediation. So first you go to that mediation, and if nothing happened in that mediation, you go on file, right? So when we file is, again, to get the attention and to get paid according to Pemex, because I think we had the right to get paid with the concept that we have in our contract. But at the end, they decided to challenge everything. Of course.
Okay, many thanks. I don't think the tribunal has. Yes, Alain. I think we are. The stenographers are exhausted, but bear with us for a little while because it's going to be short. Alain.
I have to be short. Yes, I
No,
will.
no. Otherwise, if you have many questions,
I just have one for me. Apparently, it's the last one, but you never know. When your attorneys told you that the only possibility to get your money back was to go to court, did they remind you that there was two, maybe even three possibilities, either to go to the national judiciary in Mexico, which could be administrative or civil, and on the one hand, or to go to the to arbitration, international or exit arbitration?
Well, when I heard the first time arbitration was when I started talking with Holland Knight in middle 2020, 2021. Back then, I just followed the advice with my Mexican attorneys in Mexico.
But did they explain that there were two possibilities?
No.
No. Attorneys want always to make their way alone. Thank you.
Well, I hope there is no follow-up questions. Otherwise, and follow-up to tribunal's questions.
I do have, because it got really confusing, at least for me, about what happened in the initiation of the lawsuit in 2016. And there was conversation that someone, and I think Mr. Sterneman was asking a direct question that wasn't being answered, and I want to try to get the answer. Mr. Kerning, I think you said someone at Pemex told you that you needed to file a lawsuit against Pemex to get Pemex's attention. Is that correct?
That is correct, yes.
Who told you that?
It was the contract department.
Do you have a name?
No, I cannot remember.
Okay. And I think there were questions about paragraph 85. If you could please look at paragraph 85 again.
Okay.
You say that Pemex officials from the contract and legal department told us that it would not pay us anything while our lawsuit was pending. Do you see that sentence?
Yes.
Do you recall the names of anyone who told you this?
I cannot remember.
Okay, thank you.
Mm-hmm.
Mr. Becker? No.
We have no further questions.
Wonderful. So we have come to the end of this session, and many thanks, Mrs. Carrion, for your
Thank you. Thank you.
Participation.
Thank you.
We are now breaking for lunch. My question is, shall we stick to the extent that we are still ahead of time? shall we stick to our agenda? And today's, we'll have only the direct examination of Mr. Lustenau, or could we move part of that, of the cross-examination to today, so that tomorrow we are not under that tight deadline for Mr. Lustenau to leave for the airport? So we can stick easily, or we can make a...
Can we come back after lunch?
Okay, so after lunch, so we'll resume at 2 o'clock, 2:05, we'll be back.
Where's Mr. Lieutenant first examination?
Yeah, is he ready?
Yes.
El señor Lustenau ya está.
He's here at ICSID.